the license, that's the worst one, right? That one means you're excused. You may not do this anymore. So revoking the license. Reprimand is the opposite. That's the other end of the spectrum. That's basically a note in the file, slap on the hand. You need to do better. Try to improve. So it's reprimand, and then let's see. Do we have the other one? We have 3 out of the 4. Reprimand. Yeah, there we go. Reprimand, censure. It's kind of like a reprimand. Suspension, and then revocation, revoke. The one about the public shaming is pretty much what happens when they publish your disciplinary action in the bulletin, and I kind of jokingly call it that. But that is what happens, and it is a Googleable, searchable online listing. So that's just part of it. Now, notice those are the 4 things that they can do. When you get in trouble in general, just in lots of different things in life, there's another thing that could happen in other industries and other areas of life, and that would be being fined an amount of money as a penalty, as a discipline, as a punishment. There is no such thing in real estate, kind of. Let me say it this way. The Real Estate Commission, write this one down. The Real Estate Commission will not fine licensees as a part of disciplinary action. They don't fine us. They will do one of those other 4 things. And like any good rule, there is an exception to this rule. There is one case and one type of licensee that the Real Estate Commission might fine as needed. They can fine a timeshare developer. If it's a timeshare developer and they don't follow the proper guidelines in developing their timeshare project, they can be fined $500 per violation. $500 per violation. So that's something you need to remember when we get to the timeshare section. We'll talk about that later. But they can fine not every licensee, but only timeshare developers, and it's only in a timeshare violation situation. $500 per violation. So if you think about it, and the timeshare complex has like 10 units or 100 units, and there's a violation for all 100 units, that's $500 times 100 units, right? So that could add up pretty quick. How many real estate commissioners on the board are there? How many commissioners? Wow, that was quick. Nice. Good retention. It's 9 total commissioners on the board, yeah. And how do they get onto the board? How are they placed? How is it determined that they are a real estate commissioner? Also good. They are not voted in. They are appointed, right? Appointed by the governor. There needs to be 7 appointed by the governor, 1 by the NC House, 1 by the NC Senate. And how many years does a real estate commissioner serve their term? What's the term? Very good. Good job. If you haven't answered yet, make sure that you answer. I want to get on the chat record. I need to have proof that everybody's participating. So, yep, 3 years. 3 years to serve on the Real Estate Commission. And then how many people on the Real Estate Commission have to have a real estate license? How many of them have to have a real estate license? Out of those 9, only 3 have to have a license. How many are not allowed to have a license? How many real estate commissioners should not have a license? And that one is right. Good job. That's 2. 2 without a license At least 3 with a license. Good job. What are some of the things that an unlicensed person can do in the real estate business? What sorts of activities are allowable for someone without a license to do? Unlicensed people without a license, there's certain things they can do. I'm seeing some good stuff showing up here. Well, that's a good point. Yep. Yeah, some of these that you guys are saying are entering in data into the MLS for sure, answering calls and basically reading the facts off of a data sheet, showing rental property, houses for rent, properties for rent, not showing properties for sale. Nobody answered that. So good. And somebody said sell their own house, which is true. That is true that you don't need a license to sell your own house. Acting as a courier, putting on lock boxes and yard signs. Those were all some of the unlicensed activities that are allowable. And then what is this limited non-resident commercial broker? What kind of real estate are they allowed to do? What can a limited non-resident commercial broker do? It's kind of obvious in the name. Could a limited non-resident commercial broker from another state, licensed in another state, come here to North Carolina and sell someone a house to live in? There you go. You're getting the hang of it. Yeah. Yep. They are coming here to do commercial. That's what the purpose of that special kind of little nuance. Remember, we saw there's only 275 of them of limited non-resident commercial broker licenses. It's for commercial use. Someone who is licensed in another state and is a resident of another state, not of North Carolina, coming here to do commercial on a very limited basis. And they have to work under the supervision of a North Carolina licensed broker. Here's a nuance to this. I've seen this on a practice exam. So write this one down. When that limited non-resident commercial broker comes here, they have to work under the supervision of a North Carolina broker. Just a broker. It doesn't have to be a broker in charge. Now, if they're working for that broker's probably under a broker in charge, but it wouldn't be like a directly under the broker in charge kind of arrangement. That's what I'm getting at. Just any North Carolina broker is who they will be supervised by. Okay. Let's see. Is it commercial for the company they work for? They can only do commercial real estate while they're here. That's the purpose of it. Okay. Try again. Yes. That's the kind of thing we're talking about. Right. Right. Now, I guess there's a possibility that some out-of-state firm company could own real estate in North Carolina and not be a resident of North Carolina, and maybe they would send their person here as to get a non-resident, a limited non-resident commercial license, so that they could come and list that and sell it. I guess that is a possibility when we think about it, but I always think of it as more of a coming here to buy something kind of a situation. That broker, someone says, does that broker get a percentage? I'm sure there's some kind of a split or compensation involved. They're probably not doing it just out of the goodness of their heart. So I'm not exactly sure. You don't need to know that for the test, but but yeah, I'm sure they're getting paid in some way. Okay. Now, let's hit a couple more highlights. Little reminder again, here is what we're working with. Here's your material. There's some more stuff too, but there's definitely the syllabus. That should be your best friend. A lot of times people ask me questions and my answer is, did you look in the syllabus? Because that's where a lot of the answers are as far as what topics are being covered. So remember, the textbook there, the third one, second one from the end on the right, the textbook has more information than you're required to know. How do you know which stuff to pay attention to? It's in the syllabus. That's why you should look at the syllabus section that we're going to be covering first, and then open up that chapter in the textbook and check out the keywords, check out the objectives, skip to the end and check out the summary, and then get into the actual meat of the chapter and look for those same words and phrases and topics mentioned from the syllabus. Make it your goal to go through that chapter maybe a couple of times. Maybe the first time you don't even read it that much in depth. You're just looking for terms, and you try to find the ones from the syllabus and highlight them in the textbook. And then maybe you come back and you read it more thoroughly, or you do whichever order you want. Maybe you read it thoroughly first, then come back and highlight, make sure you hit all of the things mentioned in the syllabus. Or maybe you read it pretty thoroughly and hit the ones that you can just notice, then you go back through once or twice more to make sure you got everything. Whatever speaks to your learning style the best, because everybody's a little bit different. And you need to do what's going to be retained in your head the best. And then we've got the Relink book on the far right, and that's more of the process of getting your license. There is some of that stuff that could show up on the exam, but it's more of here's the order of events, and then on pages, I think 15 and 16 or 16 and 17 in that book, in that PDF, there's the chart showing how many questions coming from which topics, which is useful, particularly when we get to the review stage. And then finally, the second one in, the License Law and Commission Rules there in the green title, that booklet is representing 3 different PDFs that you have access to through the Google Drive. Go ahead and tell me in the chat if anybody is having trouble getting into Notion, accessing, or have you even tried? Have you tried to get into Notion yet? Any difficulties? Not everyone has gotten there and left me a message yet. So make sure that you do that. If you're having any trouble with that, someone did reach out earlier today, and I hope they got that squared away. But let me know if you do, because that's the best way that I'm going to keep you updated. Because when something gets posted, it'll ping your email, and you'll know to look for it. And then when you make a comment like, "Hey Neil, could you explain this topic a little better?" It'll ping me, and I'll know. And then I'll usually, if someone asks me a question, I'm going to make the answer available to everybody, because the odds are everybody has a question, something similar. Perfect. So I'd love for you to, after class or during class breaks maybe, interesting. Someone says they can't make comments on it. I might have to maybe take you out and try again, put it back in, and I'll try that. So let's work on that between now and next week, that everybody has made a comment on there. Okay, I'll see 2 of you who have a difficulty with comments, so I'll re-invite you, see if that works. Okay, so in that Notion application, there's a link to the Google Drive, and I'll probably just email you that link so you'll have it on hand regardless of where you stand on Notion. There are 3 PDFs from this booklet. One of them is about the license laws, and the number is like 93A. That's how you know it's a license law. There's another PDF about the commission rules, and that number is 58. And it'll also be like a decimal 16 or 1500, 1600, stuff like that. And then there's also the one that you should start with called the comments section, the License Law Commission Rules comments section. That's the one that you should be reading 5 or 6 pages a week or more Get through it many times. Don't just read through it once. You need to read through it several times between now and the end. It's also going to reference the license law section in the comment and the commission rules section too. So it's just a sort of a nice guide written in an easy to understand format. Oh, and in addition to these things, the other resources we have available is a midterm exam that is purely just for your own, hey, where do I stand? How am I doing? That'll be your first experience applying the content we've learned up to that point to an actual test scenario. So a midterm, and then we have 5 practice exams to share with you. So I'll send those out around that same time. Exactly. Yeah, the license law and rules comments PDF is 23 pages. You got it. That's right. Read that one several times. Yep. Okay, let me see here. And then another resource that someone has already asked, let me see, about testing practice, because that is, if you've taken any sort of professional education where passing a test is required, the actual taking of tests is really the best way to prepare. Once you get a handle on the content, what you really should be doing is taking lots of tests, because you've got to apply that content in the form of a test, and that way, therefore, wherever you can go to take lots of practice tests, the better. And here's one of those places in the chat. We are now back to where I can chat. Everybody sees everything on the chat, just FYI. So when you are typing things in the chat and you want to type just to me, you're going to need to highlight just me at this point. But there it is, Learn, Test, Pass. That is also the company that we're going to use to give you your final exam. So on March 21st, when we give you the final, you won't come into a room and see me like this. You will get a link a couple days before that where you will click on the link. It'll take you through the actual online exam. It'll just be you. Fair warning, because it's online, they are really strict in the rules for administering the test. They have no control really, like they would if you came to their location. Therefore, you've got to like hold your camera around, spin the room, show that you don't have papers out. They record your face the entire time you're taking the test while simultaneously recording your screen to see what you're looking at and recording the audio so that they can hear if any papers are rustling or people are talking. So it's like really, really strict, just so you know. And that's pretty similar to how you would do it on the PSI if you choose to do the remote method of testing there too. It's just the only, they have to, right? They got to preserve the sanctity of the test. So Learn, Test, Pass is who we use because they have the technology set up for that. And they also have a bank, a database of 1,200 practice questions. You can pay money. I don't make any money. I don't make any sort of kickback off of this. It's just a good resource. I've done it. I've paid for it myself. You don't get it forever and ever, but you pay, I think it's like $50 for 90 days. These might be wrong numbers, but they're close. Maybe $75 for 120-day access to their bank of practice questions. And you'd pretty much say, okay, give me a test for this many questions, and they'll just put it together. The system will, right? The robots, the algorithm will put together a 30-question test for you, if that's all that you have time for in that moment. And I'm sure over time you probably are going to see some of them repeats, which is good. I think they might scramble the answers, though, so you can't just think, oh, this is the one where it was C. But they do a good job. I think they're pretty well written, and it's certainly going to be of a similar tone as what you're going to see on the final, so that's probably worth it. How close is it to PSI? I don't know, but closer than the quizzes at the back of your chapters. Pretty sure about that. Okay, so there's a resource. PSI has a practice exam as well, by the way, that you could take. And I can't recommend them highly enough. I wish I had a bank of questions saved up. I always keep meaning to make my own and make those available, but I just haven't done that yet. Okie dokie. Where do we go? 605. Okay. We covered this in our little review a few minutes ago, but let's hit it again so you can actually see it. These are the ways we get disciplined, but the Real Estate Commission, NCREC, North Carolina Real Estate Commission, does not fine licensees except for timeshare developers. And then out of that comment section, let's look at some stuff about that. On the comment section, here's what that looks like. This comment section of 23 pages has a lot of references to license law and commission rules, the easiest way to kind of get your hands around this topic. But out of this entire comment section, there's definitely a handful of items that are not covered in the comment section. How do you know what those are? I mentioned them last night. Go over to the syllabus. And oh, here I go again with the zooming. You'd think I would learn. And look up section 21, which it looks like it's page 105 in the syllabus PDF. And if you go down to see A, it says A, go to section C. And the top of section C tells us this section is not discussed in the license law and commission rules, but it has to be covered. So what are we talking about? Just super basic stuff. I think we've covered it all. So let's just look through it real quick. There's 10 items here in this C section. And these 10 items you won't find in the comment section. So make sure you cover both. That's why you should stick to the syllabus, right? Okay, licensing of individuals. What does it take to get a license? Well, we know what that is. Take a 75-hour course to get your provisional license. And then once you get your provisional, you have 18 months to get your post-licensing classes done. So provisional broker, pre-licensing, and post-licensing education. That's it, right? 3 30-hour classes for post, 1 75-hour class for pre, which is what you're in now. Termination of provisional status. That's taking those classes to get rid of provisional. And what happens if you don't take those post-licensing classes within 18 months? Your license goes inactive. Your license goes inactive. They make a little note here that credit for post-licensing courses is valid only for 2 years from date of completion. So, for instance, if you took a post 2 years ago, your license is inactive, so that's a non-issue. You're going to have to retake that post if you don't get all of them done within a 2-year window, right? License expiration and renewal. When you see the word expire, think about a parking meter because that means money. Expiration means you didn't pay your $45 to renew your license. And so you have to renew that license by paying $45 by June 30th, or your license does not go inactive. That's a testable question. What happens if you don't pay your $45? Don't say it goes inactive. Say it expires. Your license is expired. Continuing ed, we covered that already. 2 4-hour classes, total of 8 hours, an elective and a gen up. And if you're a broker in charge or BIC eligible, instead of a gen up, it would be a BIC up, broker in charge update. Active and inactive license status. We know the difference. Inactive is about education and affiliation. You're inactive until you affiliate with the firm. I've heard of agents before who got fired from their firm. It's a weird story. I'll tell you sometime. She got fired from the firm, and then come to find out she was actually continuing to do real estate before she hooked up with a new firm. So there's an example. It's not always about a brand new person who hasn't affiliated yet. It might be somebody who is in between firms and still, because the general public doesn't know the difference. And who would? Nobody, until someone looked you up and saw that you were inactive. And whoever does that, no client, unless they're mad at you, is even going to bother or even probably know how to look you up. License reinstatement rules. Depending on how long it was since you went inactive, you're going to have to do more education to reactivate. Now, here's an important point. If you go 2 years without paying the $45, then what do you have to do to reinstate yourself? If you don't pay $45 renewal fee for 2 years in a row, then you're back here with me in pre-licensing. How about that? Let that sink in. In other words, what if you get out of here, you get your license, you activate, you go 6 months, and maybe somebody from your past, some employer from your past calls you up and says, we really miss you. You did such a great job. Can I talk you into coming back? I'll give you this. And it's just too good to pass up. And so you decide to just put your real estate career on hold and go work at what I call a real job, a W-2, right? Salary job. And you do that for a while. And in the meantime, you forget about the real estate license. You forget to renew it. You forget to keep doing your CE because things are great in your normal job. And then maybe 2 years has passed and you decide to get back into real estate. Well, if you haven't been paying that $45, you got to go all the way back to here, right? So in other words, if you ever decide not to do this for a little while, you can just stop doing the education. Don't worry about the education, but definitely keep paying the money. Always pay the $45 renewal. That's kind of the lesson that I draw from this. And let's think about the numbers. Do you remember how many active licensees there are in the state of North Carolina? It's like 82,000. If you have a calculator handy, punch in 82,000 times $45 a year. That's a pretty nice, solid budget that the real estate commission has to work with. All right, it's like $3.5 million. Yes, good question. Dion says, do we get a notification about the renewal? And yeah, we do. In fact, they will send that out, and your BIC will do a good job, most likely, of making sure you are reminded about this. And we can actually start paying that $45 as of May 15th. So anytime from May 15th to June 30th. I don't think you're tested on May 15th, but just for your information, you've got like 45 days to, is that right? Does that add up? To pay that 45. Okay, what else? Broker supervision of provisionals. Brokers in charge have to supervise provisionals and keep close watch and be available and guide them through their transactions. There should never be a provisional who gets in trouble and says to the commission, well, my broker didn't tell me how to do that. And there should never be a broker in charge who says, what went wrong? This is the first I'm hearing of this transaction. They should be tuned in enough that they know what every provisional is doing. And that's kind of a big deal, because some firms have like 100 provisional brokers, and that BIC is over 100 provisionals plus the non-provisionals on a lesser scale, but that's a lot. I'm waiting for the commission to put out some sort of a maximum provisionals that can be under a given BIC. It would be interesting to see if that happens. But there's a lot of provisionals that some BICs have to be in charge of. Payment of the fees, we just talked about that. Proof of licensure, there's one we haven't covered. You are required during any time you're doing your real estate activities, you must carry an image or the actual license. It's a little pocket card, just a little driver's license shaped card. It says your name and your license number and what you are, PB, provisional broker, or just broker. So you've got to carry that around while you're doing real estate activity. Got to carry proof of licensure. You could just do a screen grab of it and then just have it on your phone, as long as you can produce it. I've never had to produce it in the field, but you got to have it close by. And then these last two, we already know. Change your name or address, must tell the commission within 10 days. Report a criminal conviction, must tell the commission within 60 days. And that's it. That plus the comment section will get you a long way toward what you need to know for license law and commission rule. Here's the requirements. You probably know this already, but you must be at least 18. Oops. You must have a social. You must be either a U.S. citizen, qualified alien, or have a work permit. Here we go. And got to pass this course and pass the PSI exam and submit a background report and have a character study as a part of that too. All that kind of comes around later. Again, I'll remind you, it'll be about the midpoint of class where you should probably go ahead and order your background report, because once you get it, it's good for 180 days. So if things drag out and you get past 180 days and you then, like I had this happen the other day, a past student, a couple years ago, reached out and said, I didn't pass the PSI back then. I want to try it again. What do I need to do? And I had to remind her, not only she was good as far as she didn't have to take the course again, that was still within 3 years that the course is good for, but she is going to have to get a background search done again and pay again for that. Right. It's a $100 fee to apply with the Real Estate Commission, and then a $56 fee to take the test with PSI. Total of $156 to do that whole PSI and apply kind of a thing. And go. Pre-licensing course is 75 hours. The post-licensing courses are 3 30-hour classes within 18 months. And then CE, 8 hours total, 2 4-hour classes. I know I've hit you hard with this like 18 times, but they test it on it. They throw it in there. It's an easy point, right? And by the way, the test, both the final exam and the PSI, every question counts the same. Just a little side note, especially when we get into some of the math, some of the questions that you're going to be more worried about maybe, don't just sit there confused and just try to spend forever figuring out that question. Skip it, because it's online. You can just bookmark it and say, let me think about that and come back to it later, and use that feature. There's no sense in eating up 20 minutes just trying to prove a point to yourself, especially if it's like a big, long math problem. Do all the ones you can do in like a matter of 30 seconds each or less, and then come back through and think about the ones that were giving you trouble, because they're all worth the same. So we could say that post-licensing, that provisional status is a temporary status. And then, here's the other thing. This is another one that could show up on the test. When you take a post-licensing course, it's a 30-hour course, and there's 3 of those. Can any of your post-licensing courses count toward your continuing education requirement? Does post count toward CE, or does CE count toward post? And the answer is no. You can't double duty. None of all of that CE that you take, none of all of that post you take is going to count for each other. Got to take those 3 30-hour posts, got to take 2 4-hour CEs every year. And then our dates again, June 10th for CE, June 30th for paying dues. And then finally, a provisional broker cannot act independently. They have to be supervised by a broker in charge, and that BIC is held accountable for the actions of that provisional broker. Okay, we've hit you in the face with all that over and over and over. Hopefully it stuck. Now let's talk about some level 3 material. Some level 3 stuff. When you're out there in the business doing work for clients, we as brokers are held to a higher standard than the general public when it comes to real estate. We have to disclose what we know about a property. Doesn't matter if we represent that person or not. Even if we represent a seller helping them sell a property, if we know that the pipes are leaking, or that there is excessive mold in the crawl space, or that it has termite damage, or radon, which is a colorless, odorless gas, anything that is a material fact, which we'll learn about in a minute, what is a material fact, we must disclose it as a broker. Even if it's our own client and our client says, don't tell them, but the roof leaks when it rains real heavy. Hopefully the problem there is you didn't explain this soon enough. Now you've got to tell your client, well, I wish you hadn't have told me because you told me, now I have to tell it. So it's a good practice to tell your client, look, before we talk about your property, let me explain how it works and what your rights are as a property owner. That property owner is required to provide a 4-page property disclosure. It's called a Residential Property and Owners Association Disclosure. There's a nice acronym for that, and that acronym is RPOADS, RPOADS. It's kind of how we pronounce it. Sounds like toads. RPOADS in the chat. And that is a requirement. Even if you're selling your own house by yourself, you're supposed to provide this disclosure. But here's the trick. Here's the kicker about this disclosure. Even though you have to provide it, here's what it looks like. It's a whole bunch of questions about the property, like does the roof leak? How old is the heating and air system? What kind of pipes are there? And then with all of these items, all these questions, off to the side, there's 3 boxes. A yes, a no, meaning yes, there is a problem with this one. Or no, there's not a problem with this one, we're good. Or this one says no representation. Basically, I'm not telling, and you can't make me. That's essentially what that means. And that seller has the right to check no representation for the entire disclosure if they want to. Why wouldn't a seller always check no representation? Well, maybe they're worried that a buyer would assume the worst and think, well, if they're saying no representation for everything, there must be something wrong with it. And that's a fair point. That could be. And I've heard of attorneys who are selling their house, and an attorney is all about limiting liability. So an attorney, when they were explained this, she said, well, shoot, I'm checking no rep because in my business, you get out of liability anytime you can. And that's a fair point, right? But even if that seller checks no representation on the entire disclosure, but you, their broker, knows about a problem, you still have to disclose it. Are you picking up what I'm putting down? You see the difference there? That's pretty big. So what I do on a listing appointment is say, hey, Mr. Ms. Seller, here's the property disclosure. You need to fill this out. However, you can check no representation if you want to just not answer a question, but I can't. As your broker, if I know that your roof leaks, for instance, I have to disclose it no matter what. Now they're ready. Now they know what the rules and laws are. Now they know how it works. By the way, this disclosure I was talking about, the RPOADS, you're not allowed to fill it out for them. And we're in a pretty high service business. It's all about making it easy on the client. But as high service as people tend to be in this business, this is one thing where you can't do it for them. You can't bring it filled out for them. They have to fill it out, put the pen to paper themselves. You can guide them. You can say, oh, here's what this means. What kind of pipes, plastic, polybut, what are we talking about? You can explain things, but you can't take it out of their hands and fill it out for them. We'll get to that in chapters 7 and 8. So these things that we must disclose are material facts. What are they? What do I mean? Yeah, please, sure. You bet. You bet. And that's a great point. It leads to another point, which is we as brokers have a duty to discover and disclose. We have a duty to look for things like that. Now, that doesn't mean we need to jump up in the attic or down in the crawl space and get all into the dark corners. But as we're just walking through, looking at the property, if we see, and it's not unheard of to open cabinet doors and look under the sink, that level of observation, whatever we see must be disclosed. Good point. Yeah. So when that happens and you're on that walkthrough with them, you see the leaky roof or ceiling is pretty clear. I just stare at it. And they might keep on walking and talking, and they eventually realize that I'm not walking right behind them anymore. And they're like, oh, well, you see, and you get the story. And they might say something like, well, that was before we replaced the roof. It just still has a stain. Do you think I should paint it? And I would probably say, yeah, let's do that. That'd probably help us out, right, on the sale, as long as it's a fixed problem. We don't want to cover a problem that's not fixed, but it opens the dialogue, which is really important. But yeah, you hit on a good point. Whatever you observe is a material fact, not just stuff that they've told you. And we do have a duty to discover. It even has been told in a CE class before that turning on the dishwasher and making sure that that works, that's within our scope of expected responsibility. So it does not mean that we have to go up into some deep dark corner of the attic and find the water heater, but a normal showing, whatever we see from there. There are 4 types of material fact categories. Number 1 is the one that everybody thinks of. Like you said, leaky ceiling, leaky roof, leaky plumbing, electrical problems. You flip a switch and something doesn't come on or off. Water heater problem, heating and air. It's not heating enough. It's not cooling enough. All of that stuff, which is bullet point 1 about the property specifically. So those are material facts. Material facts also include things that affect the property but aren't about the property. What am I talking about? Here in Concord, where I live, we have a very big business, and it's next to another big business. The big business it's next to is the Charlotte Motor Speedway. And the thing that's next to the Charlotte Motor Speedway is a landfill that serves 7 surrounding counties. It's a major operation, and it's pretty well done. It's very scientific. They constantly, I see in the distance little yellow Tonka trucks, the little, dump trucks and backhoes, and they're turning that stuff and burying it in plastic. And from what I understand, you don't really smell it when you live near it. There are some neighborhoods near there. There's a big grassy hill, like a berm that keeps you from seeing the trash itself. And occasionally I've seen, while driving through, maybe 1 or 2 loose, like grocery bags, plastic grocery bags blowing in the wind. But for the most part, you'd never know. Even the smell, there's really none. I did happen to see on a neighborhood Facebook group just recently, somebody mentioned the smell that they were noticing. But as a broker, I just need to disclose, oh, you want to buy a house in this neighborhood? Well, that grassy knoll that you see over there, on the other side of that is a landfill. Fair warning, FYI, just related to the property. Other things like that are related to the property could be like an airport. So like a traffic pattern, air traffic that's noisy several times a day, or a train that's nearby, train tracks are nearby. Or there's another neighborhood in Charlotte, northeast Charlotte, called Highland Creek. Anybody heard of Highland Creek? We're all Charlotte people mostly. And Skybrook. Both of those neighborhoods are big, but they have a section that's borders on Eastfield Road. And on the other side of Eastfield Road at a certain point is a farm called Wallace Farm, which does a great job of creating amazing soil. If you need to grow a good crop of tomatoes or anything, flowers, get some soil from Wallace Farm, because they used to, I don't know if they still do, have little mini horses that do what horses do, and it creates really good soil. And guess what? There's a smell sometimes. So if you have a listing out there and you know that there's that farm nearby and occasionally maybe a smell. As a broker, it's related to the property, right? I've listed a house in Skybrook before, and none of the other houses in the same general area made mention of the farm, but I sure did, because I don't want to get sued by some buyer that bought it not knowing, and then the first weekend they're in there in the summer, they smell it. So related to the property is what that means. Things that affect it, but are not directly at the property itself. The third thing here is whether the principals, there's a new word. A principal means a principal to the transaction, a buyer or a seller in a given transaction. What if the buyer's loan doesn't go through? The buyer applies for a loan to buy the property, and then we find out the week before closing that the lender denies the loan. Well, that is a financial factor, a material fact of their financial ability to complete the transaction. In the chat there, where are you saying, does the disclosure apply to rental properties as well? Is that what your question is? No, not the one I'm mentioning, not the RPOs. That's just for sales. I think what would apply to a rental property would probably be that walkthrough, to identify the status and condition of things before, so that when you leave that you'll get your security deposit back. And that might be what is why you're asking the question. But no, that RPOs is just for sales. How would you say that in the listing about I would say, and what I think I said was about the Wallace Farm, I would say this property is within such and such miles of Wallace Farm. I think that's all I said. And then at least they know, and they can go search it out themselves, go visit, and go do whatever they need to do for their own due diligence to see if it matters to them. With that, I think a break matters to all of us, so I'll see you back in 10 minutes. welcome back. Okay, so material facts. Oh yeah, good point. And I did confirm that it's actually on the website. Someone is asking about next Monday. We do not have class next Monday. We are observing Martin Luther King Day. We planned for that when we set up the course. So that is next Monday. We will not have class. We will have it on Tuesday, though. Thank you. So material facts, that's a big deal. That gets a lot of people in trouble. Material facts, things about the property, things related to the property, things about the ability of the buyer and seller to perform. Buyer and seller are called the principals to the transaction. So that was the buyer. The buyer would be an example of they didn't get their loan approved. But what about the seller? The seller in the transaction, what sort of financial issue could pop up that would keep that seller from being able to perform, successfully close on the property? Any ideas what could happen to a seller to keep him from being able to sell the house, property? What happens if you don't make your house payment for like a few months? And if maybe it turns out that seller has not been making their house payment for 3 or 4 months and the lender chooses to foreclose, and next week is the closing and the seller gets a letter from the bank saying this is the beginning of the foreclosure process, that has to be disclosed. You have to stop everything. That seller's going to call you in a panic. You are their agent. You're their listing agent. And they're going to say, oh my gosh, I got this letter. And you're going to be like, oh, I didn't know you were behind, because they frequently won't tell you. They're embarrassed. So it's good to ask. You did ask. You're supposed to ask up front, but sometimes they don't tell the truth. And now you've got this. So here's an important distinction to write down for the test. If they get a foreclosure notice in the mail, that is absolutely a material fact. But if they're behind on their house payment, that is not a material fact. Being behind on your house payment a couple of months is not a material fact. I think the logic there is they could make it up. They could just pay what they owe, get it back up to speed, and they're good. But getting the foreclosure notice is a whole different ballgame, because once they get that, now they've got to, if they have the money to get out of this foreclosure, they've got to pay what they owe on the back payments and also pay some penalties and fees to the attorney that's involved who started the foreclosure process. And it's official, legal document that the foreclosure is in the works. So that's a material fact. So you, the listing agent, would need to call the buyer's agent and say, oh, bad news. Yeah, we were supposed to close next week, but the seller just got a foreclosure notice. Now, in real life, that's terrible, but it's not probably the end of the world. As long as, in this market that we're in, as long as the sale of the house is for enough money to pay off that lender, everything that is owed, the loan amount, plus the back payments that are due, plus the penalties and fees, and they probably are. The values are high enough in this market we're in now that it's probably going to be enough from the sale to get them out of that trouble. And so by calling the lender who just started the foreclosure and saying, look, the house is on the market, it's supposed to sell for this amount of money, looks like that should be enough to pay you guys off completely. Can you at least pause the foreclosure proceedings? They just want the money. And probably they're going to be okay with that deal. They'll give you some time. So, yeah, what might happen, though, is the seller was planning on taking the proceeds of the sale and buying another house or doing something with that money, but now they've got to use that money, more of it than they intended, to satisfy the lender. So it might make their life a little more painful, but it's something that probably could work out. But in a market like 2008, back in 2008, when the property values were not high enough to pay off the loans that people had, now we really have a problem. Now, definitely the deal's probably not going to happen. It's going to fall apart. And that's the whole point of this being a material fact. Now the buyer gets to be notified that they might not have a house to buy anymore. and they've got some other issues because that buyer also put down some non-refundable money. They also paid for a bunch of inspections and appraisal and survey, and they're not too happy about all that money being out of pocket and then this house getting foreclosed. Basically, the seller's having to breach the contract, and now that's a whole other ball game we'll talk about in 9 and 10. So, the fourth bullet point about what material facts are is pretty broad. A material fact also includes anything important to the parties. What in the world does that mean? Well, here's an example. My second year in the business, I think, I started out in Charlotte, Northeast, the university area, and my first kind of bigger listing was in a neighborhood called Radburn off of Harris Boulevard in Charlotte. It's about $350,000, and that was pretty big at the time. And so I was happy about that. But the buyer who came along and made an offer and got accepted, we're under contract. Another agent represented the buyer. I was representing the seller. That particular buyer had come here from Florida. And in Florida, they have a big termite issue. We have termites here, but we know how to handle them. So does Florida, but they're bigger. In Florida, it's even bigger. In fact, they had a little toddler playing in the backyard, running across the yard playing, and a termite swooped out of the sky and carried it away. No, they didn't. That's ridiculous. But the problem is really big in Florida, so much so that it cost them a bunch of money when they sold their house down there, to the point where they're like, we don't want anything to do with termites ever again. We're moving to North Carolina. And when they got here and talked to their buyer agent, they told them, well, first of all, yeah, right, a gator for sure. First of all, if a house that you show us has any signs of termites, we're not buying it. We've been there, done that, not doing it again. Wouldn't you know it? My house, my listing that they had contracted to buy, didn't look like it had termites, but when they had it inspected, the inspector went in the crawl space, moved around some insulation, and saw some surface damage, some really light surface damage on one of the floor joists. It was such a little bit of damage that if the seller, I don't know why they would have, but if the seller had gone in the crawl space before we put it on the market, found that damage and had some sandpaper, they could have sanded it off and nobody would have known the difference. I'm not saying they should have. I'm just saying that's what little bit of termite evidence there was. It wasn't like a whole bunch of damage or structural damage or problems or anything. Well, that was all it took. To this buyer, termites, the mere presence of a termite burping on this property was enough, and it was a material fact to them. So that's what it means. Anything important to the parties is a material fact as well, that we as brokers are obligated to disclose. Here's another one. So you tell me, I'm going to give you your privacy again. So your answer will only come to me. So you tell me this. If you're representing a buyer and that buyer knows that maybe a road is coming through and therefore all the property in this certain location is probably going to be worth more in a few years when that road project starts up or gets completed. If you're that buyer's agent and the buyer says to you, go find me some land to buy in the path of this road because I'm banking on the long-term property value increase. I want to buy it up now before it's a actual widely known thing. You go knocking on doors, calling landowners in these areas. Are you obligated to tell those landowners that your buyer wants to buy their land because of this road project that is definitely coming through? Are you obligated to tell that seller that that's why that buyer wants to buy it? Tell me in the chat. Got a couple more. Need to hear from a couple more of you. Several, it's probably an even split. Half and half are saying yes versus no. And if it were me, and when it was me 7 years ago, before I knew the laws and rules, I would have been right there with you. I would have thought, well, I'm the agent for the buyers, none of the seller's business what I know, And while the buyer wants to buy, I'm looking out for my buyer. I'm not telling. But in fact, the real estate commission says otherwise. It's actually that exact scenario they mention in something I saw somewhere, some CE course or something, or a practice exam somewhere along the way. You would have to disclose it. That is the level, that's the height of the level of as a broker that we are obligated to disclose material facts. So the actual answer is yes. You would have to tell that property owner, my buyer wants to buy a property here because the road is probably going through around here. And so, are you interested in selling? You've got to disclose it. Isn't that crazy? I thought it was, but that should just give you a good insight as to how much responsibility we as brokers have on disclosing material facts. What happens if we don't? We get disciplined by the commission. We get a complaint, maybe somebody makes a complaint and the commission looks into it. Anytime the commission gets a complaint about one of us licensees, they, first of all, are going to decide if the complaint merits an investigation. Because people could get mad at an agent and complain for no good reason. I've put it back to the chat windows to everybody, by the way. So just because they're mad at us doesn't mean it's a valid complaint. So step one, when they go to the website, let me show you how easy it is to make a complaint. Step one is the commission has somebody look at the case and see if it's a case. By the way, you'll learn this shortly. I'll go ahead and tell you now. If somebody has died in a property, that is not a material fact. Death in the property is not. Who would be bothered? Hands up in the window. Who would be bothered if you found out later that you bought a house that somebody died in? Would that bother anybody here? I see a couple. I see about half. And that's fair. I get it. I don't know if it bothered me or not. It's hard to know until you're in the situation. But that happens to be one of the things that is not a material fact. We as brokers, if we know that somebody died there, we don't have to offer it up. We do not have to disclose it. And if they ask, we could say one of two things. If somebody says, did somebody die here? You could either say, I refuse to answer the question, which is an answer in and of itself, or you have to tell the truth. You can't lie about it, but you would have to tell what you know if you choose to tell something. So here we go. This is the Real Estate Commission website, ncrec.gov. And if you just scroll down a little bit, right there at the bottom, file a complaint. You click on that button, you start filling in blanks. Who is it? What broker are you complaining about? What's their license number? What's the details? Submit additional documents, maybe photos, whatever else. That's how they get complaints. Someone could also call. But they're not going to immediately send the letter to the agent and say, we got a complaint. Now you need to tell your side of the story. The first thing they're going to do is say whether or not it's a valid complaint to pursue. So if somebody calls and says, this agent didn't tell me that someone died here, that person at the commission is going to say, well, I'm sorry, but that's not a material fact. They didn't have to tell you that. Did you ask them? No. Well, they don't have to offer that up. And that person's still angry, but the agent's not in trouble. And so they may not even know. They probably aren't even going to tell the agent that somebody even complained about them because it's not a valid complaint. So that's sort of the chain of events. If they do determine that it's a valid complaint, then the process is this. The commission sends them a letter. They also send it to your BIC, and they say, look, someone's made a complaint. Here's the situation. Within 14 days, we need to hear your side of the story. Give us your side of the story plus supporting documents, the stuff from the file, because you got to keep your files for 3 years, right? So send us these items. By the way, the commission says just send what we ask you for. Don't send anything more. Don't send us extra stuff because then we're going to have to look at it. And it might be that it gets you in more trouble. They literally said that in a session that I've been in before. So just send what they ask for. And also, if you get called up before them because of a complaint like this, take an attorney with you. Don't assume the best. Be ready. Make sure you have accurate and solid representation. So it's worth it to keep your license, to stay in, to make sure you don't screw up by saying something or saying something in a certain way. So these material facts must be disclosed, or the licensee could be guilty of something we're going to learn about next: misrepresentation or omission. Did you say something wrong, or did you not say something but you should have? That's what those things mean. Somebody's asking about ghosts, and that is another something called stigmatized property. So death in the home is not a material fact. It's called a stigmatized property. The presence of ghosts or haunted houses, a stigmatized property, not a material fact. And then the other one is the presence of a sex offender nearby. A sex offender, look up the sex offender registry. You can look it up, North Carolina Sex Offender Registry, plug in your address, and you'll see on a map where the sex offenders are. The reason I think that that is not a material fact, and everybody just pause for a moment, you're probably thinking, that's pretty terrible. Why wouldn't that be a material fact? It goes back to, how does it affect the real estate in the deal, right, in the transaction? For one thing, I think, what if a property owner turns out they're trying to sell a house and it's across the street from what is supposedly a sex offender living there? And that property owner can't get their house sold, or they lose value because a sex offender lives across the street. I think the logic here is, for one thing, what if it's incorrect information? This is a convicted felon. Guess what? They break the law, or they have before. Maybe they say they live in a place and they actually don't anymore. Maybe they said they were going to live at that address and they went away. They don't even live there. It shows up on the registry, but they don't really live there, and it still negatively hurt the owner across the street. That's all I can come up with in my head to think why it's not a material fact, but you just need to know that it's not a material fact that a sex offender lives near the house or next door. So yeah, also I've heard, and I've never confirmed this, I don't know how to do that. I guess I could call, but I've heard the sex offender registry has a pretty high error rate. How accurate is it? I don't know. So that maybe kind of plays into it as well. But again, all three of those things you do not have to disclose. If they ask you about them, you can either decline to answer, or you say the truth, whatever you do know. If you know for a fact that there's been a murder, say so. Suicide, death in the home. Okay, misrepresentation and omission. These are the things that you could possibly be found guilty of by the commission when it comes to this concept of material facts. So let's see what that means. A misrepresentation. That means you actually said something, either wrote it or verbally said it. You expressed something that was not right to the client. That's misrepresentation. So if they ask you a question and you know that the property is zoned industrial and not residential, and they say, hey, is this zoned residential? Because I want to build townhouses here. And you're just trying to hurry up and get paid. So you say, oh yeah, it's fine. It's zoned in residential, but it's actually industrial, and there's no chance of it ever getting switched or anything. That's misrepresentation. You said the wrong thing. Or they say, I'm seeing a stain on the ceiling. Is a roof leak? And you know for a fact that they haven't fixed it, that it leaks when it's like a really heavy rain. And you say, no, there's no problem there. The roof's fine. You said something. The other one is omission. Your mom told you growing up, you lied to me. And you said, no, I didn't. I just didn't say anything. And she said, you lied by omission, right? Don't think of it that way, because saying the lie and just not saying anything but you should have are two separate things. Saying the lie would be misrepresentation here. Just not saying something at all when you should have is omission. You should have spoken up. but you did not disclose it. And then which kind of misrepresentation or omission was it? That's where these last two words come in. Willful misrepresentation. Let me skip ahead here. Willful misrepresentation means on purpose you told the wrong thing. You told them a lie. It's essentially that you told a lie because you knew it was the wrong information and you said so. You said it anyway, I should say. Negligent misrepresentation means you gave incorrect information. You told them something that was wrong, but it wasn't because you intended to. It's because you didn't check to be sure. Whether you were lazy or slack or just in a hurry, negligent misrepresentation means you misspoke. You said something that was wrong information. We are held to a standard. We need to go verify the things that we say. We probably shouldn't say anything until we verified it. So if a client asks you a question, a good rule of thumb is to say, that's a great question. Let me go check on that for you and I'll let you know. Don't just pull from air or other places and come up with an answer just to have an answer. I used to be really, I guess I had a chip on my shoulder coming straight out of college, getting into real estate, and everybody I was working with was older than me. I didn't even own my own house. I lived with parents. And so I was scared to death somebody was going to jump out of the bushes and say, you don't even own your own house. Why are you helping me? But they never did. And I always felt like I needed to have an answer for them. And it's that kind of thing that sets you up to maybe do this kind of stuff. But don't give in. Embrace what you don't know. Own it. Because that's a sign, I think, of intelligence. Surrounding yourself with people that do know stuff. So after 26 years of in the business plus teaching for the last several, I know a lot of the laws and rules, but I still don't know everything. And so if it's the least bit shaky and I'm not 100% sure of what the answer is, even if I'm 90% sure, I don't want to do this. Therefore, my answer is, I don't know. Good question. Let me check on that and I'll get back to you. With that tone, right? Sort of a, yeah, good question, acknowledgement. And not an answer that you're giving them without knowing for sure. So that's the misrepresentation. And then omission means you didn't say something, but you should have. You omitted it. So willful omission would be that you knew for a fact that you needed to tell them something and you chose not to. Willfully omitted that piece of information. The other kind is that you should have told them and you didn't even bring it up because you never bothered to go find something out. Like they might ask, well, it might look like this. As you're showing the house, you're in the backyard and here's the house. Here's the line, the property line. Well, here's the house next door. And then here's the other house. And these houses have fences in the backyard. And so this one that you're showing does not. But you see the lines for the fences back here. Let's pretend that these line up. Let me make them line up there. You see this corner of this guy's fence and this corner of this fence, and they ask you, well, I figure the fence line is probably right along there, huh? And you say, yep, that's it. You've told them something without checking. What are you guilty of if that's incorrect? If this is actually not the fence line, it just so happens that the fence line is right here for some reason, and you've told them less, that the property actually has more than it really does. You say, yep, you're right, and then you never check to be sure. What did you just commit? What are you guilty of in that situation? Which of these four possibilities, willful misrepresentation, negligent misrepresentation, or willful omission or negligent omission? It's a little confusing when you're really trying to apply it, isn't it? But here's one way that might be helpful. Think about the second word first. Decide if it's a misrepresentation or an omission, and then later, after that, after you figured that part out, figure out if it was willful or negligent. So the question was, the client said to the agent, "Is that the fence line? Is this the fence line?" So that it lines up with the neighbor, and the agent doesn't bother to check for sure, and it turns out it's wrong, and they say, "Yep, that's the fence line," when in fact it's not. So the agent has said something. They expressed something. They gave an answer. Therefore, we're talking about misrepresentation. Which kind of misrepresentation? We're talking about negligent misrepresentation because they didn't verify before they gave an answer. You with me? It's a little tricky. Thankfully, in the comments section of that comment section PDF, one second. Here we go. There we go. I think around page 5, there's the section on material facts and these 4 possible words. Here it is. Willful misrepresentation down here occurs when a licensee has actual knowledge of a material fact but deliberately misinforms. And then it gives some examples, real world kind of examples of what is of a willful misrepresentation. Let's look at a couple. An agent knows that a listed house has a problem with water intrusion in the crawl space during heavy rains. In response to the question from the buyer, the agent says there's no water drainage problem. So they know for a fact that there is, but they say something otherwise. They said the wrong thing on purpose, willfully, to deceive. What about this one? An agent knows that the heat pump at a listed house doesn't function properly, but tells the buyer that everything's working great. Again, they said something that was wrong, and they knew that it was wrong. This one's my favorite one. An agent knows the approximate market value of a house is $225,000. They know this because they did market research, did a report, and verified things that have sold recently, and made some adjustments and determined this house is worth $225,000. They know this because they did the work. But they tell the owner on the listing appointment when they're trying to get hired to be the listing agent, they tell the owner what the owner wants to hear. The owner wants to hear that it's worth $250,000 because that's what they want. They would rather have $250,000 than $225,000. Guess what? That happens all the time. Sellers think their houses are worth more than they really are. And one of our jobs as the broker is to give them the bad news sometimes. What the agent should say is, well, I can appreciate that you want $250,000, but let's take a look at this market data. Let's look at my research. Here's what I found. The house down the street sold for $220,000. And here's some pictures of it on the inside. I share with them the MLS data of the similar properties that have sold in the neighborhood. And I let them figure it out themselves. I just show it. And they're like, oh, wow, gosh, looks really good in there. Their kitchen's way better than ours. And they're painted that nice neutral gray color throughout. We have a billion different colors, and we really probably should pick up a couple things. They've got it showing really nice. It's nicer, it's better to let them come to the conclusion rather than you be the bad guy. But if you have to just say, look, guys, if I had to show your property versus this property, I feel like the buyer right now in the current condition is going to probably lean toward theirs because it's ready to move in, ready to buy. They don't have to paint. They don't have to fix it up. It's good to go. Therefore, look what they sold for, $220,000. Now, do you still think yours is worth $250,000? That's more like what we should do. But what happens, I think, more frequently is a broker says, what do you want to get out of this? $250,000. Okay. And they're thinking to themselves, there's no way in the world it's ever going to sell for $250,000, but I'll just tell them that sounds good so I can get my sign in the yard, get the listing, and then I'll try to wear them down over time, get them to drop the price over the next few weeks when they don't get any showings and when they don't get any offers. Well, there's a certain point at which that's more than just a little bit of fluffing. And look, that's not much of a differential. The Real Estate Commission has put this example in the comment section to illustrate that this they consider willful misrepresentation. Overpricing a house by $25,000. Now, I'm not saying that's the magic number. I'm just saying, look, be careful. There's a lot of brokers out there that say whatever they need to say to get a sign in the yard because they know they'll probably, as long as they stay on the good side of the seller, get them down to the right price. But if somebody chooses to complain about it, if that seller doesn't take it well and realizes, wait a minute, why didn't you tell me that my property wasn't worth $250? Why did we spend 6 months before you finally admitted? And here's the thing about pricing. You can cost your seller money by not giving them good advice. Because if you price incorrectly in the beginning, what tends to happen is by the time the seller reduces to where they should have started, it's now going to sell for even less than that, because the buyers out there in the market have started to assume and see this listing pop up time and time again with an inflated price, and they don't show it. They don't make offers, and the house sits, and it sits for too long. And if it sits for 6, 9 months, a year, something like that, and never sells, people start wondering what's wrong with it. And what's probably wrong with it is their pricing strategy was wrong, but there's nothing else wrong with it. But what everybody assumes is the worst, is that it has ghosts that died and and mold problem and radon and everything else in the whole world. So you've cost your seller money by not giving them the hard truth up front, to the point where the commission will discipline an agent over this if a complaint is made. Okay, let's see here. Yeah, Florida is always really hot, and it's a good, like, the market. And whatever's happening there eventually comes here, but in a lesser format. I remember leading up to 2008, Florida was appreciating like ridiculously steep. You can, in fact, contract to build new construction, and it might take 6 months to build a new house down there. And by the time the house was done in the 6 months, you could immediately sell it and turn a profit, right? That's how steep their appreciation curve was. But then when the market tanked, it went back down just about as steep. Ours was much more moderate. So it's nice to watch other markets, California, New York, Florida, and kind of see, because what's happening there is probably going to trickle down to over here. So that's a good point. Let's see, if you list your house for sale and within 24 hours you're getting multiple requests for showings, do you think we have a good price? Yeah, I do. I think that's a pretty good price, because what you might be alluding to is, are you underpriced? Is that what you're getting at? No? Okay. Yeah, the Realtor Association has a couple of statistics, and one of them is you should be getting 1 to 2 showings a week, and for every 10 showings, you should be getting an offer. It's kind of an older statistic, but in this kind of market that we're in, we're seeing a shift. Before April of this past year, and for the couple of years leading up to that, it was an insane seller's market. Sellers owned the day. So not unheard of to get multiple offers within minutes, hours, same day, really. And for over asking price, like 50,000 over asking price sometimes. There's something we'll learn about in chapters 9 and 10. When you make an offer, the buyer provides, once the offer is accepted, the buyer gives the seller a check, a non-refundable deposit. It's called due diligence money. That due diligence money is never refundable for the most part. Even if the buyer chooses not to buy it later because it's got too much wrong with it that came about during the inspections, and the seller won't fix anything, the buyer chooses to walk away and let the deal die, they don't get that due diligence money back. Even if it doesn't appraise. If a buyer is using a lender to borrow money to buy the house with a mortgage, and that appraisal comes back and says this house is not worth what you've contracted to buy it for, I'm appraising it $10,000 lower than what's on the contract, the buyer can walk away over that, but they don't get their they don't get their due diligence money back. Some of these due diligence checks back then not so, like a year ago. Would you like to make any guesses? Just make some guesses. Let me make it confidential again real quick. 1 second. Boom. Okay, now guess. Tell me some guesses of some of this non-refundable due diligence deposit that a buyer would give a seller as soon as it went under contract. They would promise it, and then they'd have to write the check. Back in the day, 10 plus years ago, when people would ask me, how much should I write for the due diligence check? My answer was, it's that plus this other deposit called earnest money combined, about 1% of the sale price seems to be the rule of thumb. But that went out the window in these last 5 years or so. The amount of non-refundable due diligence deposit that started to be like a minimum, 5 and 10,000, but not all uncommon, $20,000, $50,000 of non-refundable money that a buyer who was really serious about buying was willing to walk away from, even if the property didn't appraise or had so much wrong with it that the seller wouldn't fix anything. 50,000. How about 100,000? Yes, 100,000. I teach CE also every year. And so in CE, I'm talking to a bunch of agents. And so I can't help myself. I have to find out what they're experiencing. And the last year's CE was right in the thick of all of this. And I would ask them every class, I taught like 30 of them, 30 classes. And they would all say, I'd say, what's the highest due diligence money you ran into, either as a listing agent or as a buyer's agent? And I would see 20 grand, 30, 50, 100 sometimes. Depends on the price range too. One person, my favorite one that stood out the most, said $400,000 non-refundable deposit that buyer was willing to walk away from. But that's not even the crazy part. My next question was, how much was the house? $400,000. You see what happened? That buyer agent basically gave the seller all the money. Said, I want to beat out all those other buyers so badly that here's all the money. Here's the entire 400. Basically, they're saying it doesn't matter what's wrong with the property. I'm buying it anyway. Right? I mean, that's insane. But then April hit this past year and the market sort of started to change a little bit. The interest rates went up. They came back down. Everybody predicted they'd get up to 10. They never did. They got to about 7. And now they're back into the 6s. So who knows? But I don't think we're going to be there anytime soon. The values, thank goodness, are still pretty good, but it's not the same selling in minutes as it used to be. So it depends as far as what you should list at and what kind of activity you get. It depends on how quickly you want to sell. The faster you want to sell, the lower you should set your price. You know, it accomplishes the goal. But if you don't want to leave money on the table and you want that seller wants to get the absolute most they can get, you've got to find that line, and they're looking to you for a good answer that is an educated answer, not just a selfish answer. Because this example we're looking at here is the agent looking out for themselves more than the client. They're not looking out for the client. They're just trying to get the listing. I call it buying the listing. They're telling the seller whatever they want to hear just to get their sign in the yard. That is what is willful misrepresentation, right? Okay, we're public again here. Let's see. So that's a pretty big one, willful misrepresentation. And then the next category is negligent misrepresentation. So I would suggest between now and next week that you read a couple of times these couple of pages about this willful and negligent. Read all of the examples. Try to think up your own example. Write your own version of one of each of these and come ready for class next Wednesday and say, here's my example of willful misrepresentation. In fact, send it to me, email it to me, and then we'll kind of look at them together. I won't call you out. We'll just say, what about this one? We'll treat it like our own created quiz and see what these things are. So I want you to write me one of each of these 4 examples. Make it up. You can make names. You can say Betty Buyer and Sam Seller, whatever you want to do, but come up with a situation for willful misrepresentation, negligent misrepresentation, and the 2 omissions. But let's look here at negligent. A licensee unintentionally misinforms. It's misrepresentation, so they're saying something wrong, but they're doing it because they should have checked. And the way they say it here is should have reasonably known, should reasonably have known. A reasonably prudent licensee should reasonably have known. What are some examples? They give us this one. An agent has previously sold lots in a subdivision, a new construction subdivision. All those lots passed a soil suitability test for an online septic system. So what they're talking about here is how are we going to get rid of the bathroom waste, right? If it's not close enough to the city limits that you can tap on to the sewer lines, then you've got to dig a septic tank. You got to dig a hole and put a tank in the ground, and that's where the bathroom stuff goes. And the way a septic system works is there's a septic tank, and then there's a leach field. Let me show you a drawing, not a real one. But here's the house, and so here's the street out the front here. And then a septic tank, they're going to determine where we should put it. And so they'll put a line from the house, all the toilets will empty out into this buried septic tank. And then from this tank, the stuff going in this tank is some of it's going to be solid, some of it's going to be liquid. I'm trying to not be as gross as possible. And then coming out of this tank, depending on how absorbent the soil is through tests, a test called a PERC test. PERC test. You might also see it called this. But a PERC test means, does the soil absorb enough wastewater to not back up and come to the surface? Will it go down into the soil in a reasonable amount of time? And so a PERC test involves taking out a core sample from the ground. They'll drill out a hole, maybe like a 2-inch sample of earth, or they might use like a backhoe and dig a bigger hole, and they'll put water in it and they'll time it and see how long it takes water to absorb in the ground. And depending on the kind of dirt that is on that lot, it may not absorb quickly enough. And so if that happens, the wording is property does not PERC for a conventional waste system. You've got to maybe bring in some dirt that does absorb and swap out the dirt that's there for the more absorbative dirt. Well, these 4 things right here are pipes. They're those black corrugated pipes that you can find at Home Depot or Lowe's. It's probably like 100 feet or more, each one. And if you want this to be a 4-bedroom home, this soil needs to PERC for a 4-bedroom home. If what you're going to build is not 4, but only 3 bedrooms, then you need to make sure that septic system PERCs for a 3-bedroom home. And again, notice that I said bedrooms. A lot of people would guess that a soil test for a septic system would need to depend on how many bathrooms there are, but that's not the case. It's about the bedrooms. The idea is that for every bedroom, there could be 2 adults. So a 3-bedroom home should be able to absorb 6 adults worth of wastewater in a certain reasonable amount of time. Whatever the code is, you don't need to know that part. So that's what we mean by an on-site septic system. If the septic permit that's done to make sure that this is built properly, if that septic permit says this septic system PERCs for a 3-bedroom home, and let's say that seller has added like 5 bedrooms, so it's actually the 3 original bedrooms plus like 2 more in the attic or upstairs, and then or maybe in the basement, that seller is probably going to want you to market this property as a 5-bedroom home, but you're going to have to explain to them, look, I would love to. However, you have a septic tank and it PERCs for a 3-bedroom, so all I can market it as is a 3-bedroom home. So that is in and of itself a material fact that you have to disclose. You can't market it as a 5-bedroom home if it only PERCs as a 3. So with that said, let's go back to this example. An agent has previously sold several lots in a subdivision, and all of them have passed a soil suitability test for an on-site septic system. The agent then sells lot 35 and doesn't check whether it satisfies the soil test. They don't have a perk test done on this one because he assumes the best. He thinks all the other ones passed, so this one will too. So the agent tells the buyer that lot 35 is good. It will support the system. And it turns out that that is not the case. The agent's conduct may not rise to the level of willful disregard for the truth, but they were at the very least negligent because they didn't check for sure. They should have had a perk test done. Or if there was one done, they should have looked it up, found it, seen if it asked for it, and therefore guilty of negligent misrepresentation. They said something that wasn't true. They thought it was true, but they said it and it turns out it wasn't because they didn't check. So it's negligence, not willful. Next example, an owner tells a listing agent with ABC Realty that his house has 1,850 heated square feet. Remember that the size of a house, the square footage of a house, is not a material fact, according to the Real Estate Commission. But if you're required to report it, and you are because of the MLS requires you to tell what the square feet is. Therefore, the commission comes back and says, well, then you better make sure it's accurate. It's not a material fact as far as they're concerned, but if you do choose to report it, you better report the right number. And we're going to talk about how to measure houses to make sure that's the right number. But this agent doesn't verify the square feet and records 1850 on the listing form and in the information put in the MLS because the owner told them. That's the worst source. Don't believe what the owner tells you. They might think they know, but they may not really know. And they may not understand the importance of it, so therefore they're rounding up, right? So house is sold by a sales agent with XYZ Realty, a different firm, right? The listing agent is with ABC. The buyer's agent is with XYZ. And that buyer's agent relies on the information that the listing agent provided. It says it's 1850. But then they find out later that it's not. It's 100 feet smaller than that. It's actually 1750. How would they find out? Any guesses? How would this buyer agent find out that it's actually smaller than what was told? There's no reason for you to know. I just want to keep you involved. That's a good point. They could. If the buyer agent does have a reasonable, they have a reasonable expectation to assume the listing agent puts right information in. So that buyer agent's not going to get in trouble if they don't measure it. But if they walk through it and it feels like it's too small, then they probably should measure it because that buyer agent does have responsibility on their shoulders to make sure their buyer is protected. So yeah, they could end up measuring it if they doubt what they're seeing. And the commission also says we as brokers have a responsibility to make sure we should kind of know what 1,800 feet feels like within a certain 5% differential. 1,800 versus 1,700, we should probably be suspicious. But another one that's actually going to probably happen, especially if this buyer is getting a loan, they're going to have an appraisal done. And that appraiser is probably going to measure it. So that would, in the real world, probably be how they discover that it's actually less than what is claimed. The appraisal comes in showing less. But in this situation, the listing agent did not make a direct misrepresentation. They initiated the chain of communication which caused the buyer to be misinformed. They indirectly misrepresented a material fact. The listing agent failed to verify. So they told wrong information because of negligence, right? And so they're guilty of negligent misrepresentation. The selling agent is not the listing agent, by the way. Let me pause. Well, let me make this point and then we'll talk about this. Let me just tell you that when you see the word selling agent, it means the agent that is helping the buyer. It never means the agent that is helping the seller. Selling with an ing on the end means it's on the buyer's side. That is the agent helping the buyer. It's called the selling agent. You need to know that because that'll mess you up on the test if you don't understand that selling ing means buyer side. Listing or seller's agent means the seller's side. That's the agent helping the seller. In this case, the selling agent, the buyer's agent, directly communicated the incorrect information. They reported back the wrong info. They probably acted reasonably in relying on the data in the MLS. It is okay for a buyer's agent to assume that the MLS data is accurate, unless it's just so crazily wrong that it's like hard to miss and they're suspicious. So if that buyer's agent, selling agent, didn't have any reason to doubt what was in the MLS, then they're not guilty. But if the discrepancy was large enough that, here's that phrase again, a reasonably prudent agent should have known better, then they're guilty. Then they would also be guilty of negligent misrepresentation. So, some weird words in here. First of all, when it comes to a complaint, the Real Estate Commission is looking for would a reasonably prudent broker have known. And then second, selling agent. Look at it this way, and then we'll take our break. But real quick, I want to get this visual in your head. Here's the buyer's side. Here's the seller's side. The agent helping the seller is the listing agent or the seller's agent. The agent helping the buyer might be called the buyer's agent. They could also be called the selling agent. And we'll get into this later. Don't let it cramp your brain too much. The agent helping the buyer could also be referred to as a sub-agent to the seller, but just ignore that. Don't pretend I didn't tell you that. But here's the important part I want to point out here. This selling agent is not representing the seller. Don't get that confused. Selling, you see that word? You think buyer side, an agent helping the buyer. With that said, I'll see you in 10 minutes. So, an agent helping a buyer is called what kind of an agent? Seller's agent, buyer's agent, listing agent, or selling agent? There you go. Take that to the bank. Selling agent. That's what that is. All right. Now, the reason I went into that was because we had gotten to an example. So let's look at that example. Okay, we've covered that example. Selling agent is the buyer agent. Another example of negligent misrepresentation. That's it. That's the only ones they gave us. But again, I want you guys to write it. I'll put it in Notion as a reminder. Come up with your own versions. They can be pretty simple. It can be elaborate, whatever you want. I'm not going to say who made them up, but I'll use them as a quiz for everybody next week. And then we'll figure it out as a class what they are. I think writing them for yourself is a useful learning tool. Speaking of that, here's another useful learning tip. Find somebody that has to love you unconditionally. The person that has to put up with your stuff so that they can't get away. And when we get into things like explaining agency and even this stuff, maybe this topic itself, run some of this by them. Try to be able to see if you can explain it to them as if you're teaching it to them. There's something about teaching that makes you learn it better. When I was gearing up to be a teacher in 2018, I watched various videos of other teachers, and I would actually vocally out loud explain some of these concepts like I'm doing now. But back then, and it's like the whole time you're doubting yourself. You're like, oh, did I include everything? Did I forget something? It doesn't matter. You could even make yourself that person that has to love you unconditionally. Pull out your favorite video camera, the one that you carry in your pocket. Record yourself saying it. I know nobody wants to hear themselves talk or see themselves. But guess what? Here's what I say when I tell agents to make content. Make content, by the way. When you get in the business, best way to build your business is to be looked at as an authority. So make video content, even if you hate looking and hearing yourself. Because guess what? What you hate seeing and hearing that is yourself is what we're all used to seeing and hearing. Tough love, right? You're the only one not used to it because you don't see yourself from that perspective. We do, though, and we're used to it and we like it. You're great. So get over it and make content. But you can also use it as a learning tool. Explain it on video and then watch it back and see if you left something out, right? Okay, that's two of them. Those are both of the ones about misrepresentation. Now let's look at the one about omission. Both of them. But this one is willful omission. The licensee has actual knowledge of a material fact. They have a duty to disclose it, but they fail to do so. So when we get to the chapter on land use controls, we're going to talk about zoning. And so if a property is zoned for industrial use, you can't put a house on it because that house is not industrial. The house is residential. The city has a say-so in what you can do with your property to that effect, right? I have this weird unicorn property. It's the house I grew up in. And originally it was on 6 acres. And I bought it from my parents in 2001. And so both my parents are deceased now. My wife and I live here. And a couple of years ago, a big developer planned to put condos in on the 47 acres behind me. And so they offered to buy 1 acre of my 6, and I sold it to them because they needed to finish out their road. So now I'm on 5 acres. But what's unique about this property is it's me and my wife and my dogs in this old tri-level 1972 brick house. It needs paint. It's not pretty. I'm not winning any awards. But here's the thing. It is zoned industrial. The zoning for this property is industrial. I won. That means the buyer, and I do have it on the market, whoever buys this is probably going to tear this house down. And I'm okay with that. And they're going to build an office building or maybe a warehouse, something industrial, maybe one of those hybrid things that's office in the front, warehouse in the back. So I'm not really interested in spending $2,000 to replace the deck that needs to be replaced because it's all going to get torn down someday. I don't know when. Might not get an offer for 2 more years. But that's my situation. I get to still live here and use it residentially because I'm grandfathered in. I had it when it was originally residential. It just changed over the years, but they don't get to kick me out. But they can say, well, you can't sell it to anyone else to use as residential because now it's zoned industrial. You see there? See my point? And then if I have like a significant amount of damage, if the house were to burn down, knock on wood, or get somebody runs off the road and knocks half of it down, I can't rebuild it residentially. So it's a matter of time before it's going to actually be used industrially. Either I'm going to sell it, or if it were to be destroyed, it can't be rebuilt. The grandfathered in thing doesn't apply to that. But for the moment, I get to live here and treat it like a residence because I was here first, so to speak. With that said, an agent knows that a zoning change is pending. They're thinking about it, and it would adversely affect the value of the property that they have listed. They fail to disclose that information to a prospective buyer. Somebody wants to buy it. The agent doesn't bother to mention that the zoning is going to get changed and that's going to make the value go down. The agent has committed willful omission. They left something out that they knew they shouldn't have left out. They didn't say it. That means they omitted it. And they did that on purpose. That means it was willful. Oh, and then here's the thing where I gave you that scenario earlier and said, what if you were a buyer's agent and your buyer wanted to buy because the values are going to go up? Do you have to tell the seller? And here's why. Here's where it actually says so. If you know about a zoning change or a major highway or anything affecting the value of a seller's property, that has to be disclosed to the seller, even if you're representing the buyer. You, the broker, is helping the buyer. You still have to tell the seller that the value might be going up. And what about this one? An agent knows a listed house has a major defect, no insulation in the house, maybe a septic tank doesn't work or a leaky roof, and doesn't tell the buyer. There it is, classic example. You know of a thing that's wrong, you just don't even mention it. You hope they don't think of it, and you on purpose didn't mention it. That is willful omission. Read all of these many times. Use one of them as an example to write your own for next week. And then let's talk about the last one here, negligent omission. Licensee does not have actual knowledge of a material fact and therefore does not disclose the fact. But here's our phrase again. A reasonably prudent licensee should reasonably have known. Do you starting to see the level that we're held to, the high level of responsibility as a broker? Do you still want to get the license? I'm just kidding. Of course you do. So negligent omission, what is that? Examples. A listing agent lists a house adjacent to a street that's going to be widened. That project has been very controversial. It's been in the papers, been online, highly publicized. Everybody knows about it. The city finalizes the decision to proceed with the project and widen the street. Why are people mad about it? Because it's going to tear up people's yards. It's going to take land from people. When you widen a street, where's the extra lane coming from? Somebody's front yard. And it's called eminent domain. The government can say, we're going to buy your front yard, half of it, so that we can use it for the street, which is for the public good, and there's nothing you can do about it. You've got to sell it. We're going to give you what we call fair market value. You probably won't agree with how much that is, but we're going to take it from you through condemnation, and that's what's called eminent domain. I'm sure some of you have heard of that. So the city finalizes the decision to proceed, and plans for the widening are in the city planner's office. A buyer is working with a selling agent. They offer to buy the house. The listing agent does not disclose the widening plans to the buyer or their agent, and then later claims that they were not aware of those plans. In this situation, both agents, listing one and selling one, are probably guilty of negligent omission because each should reasonably have known it was so publicized. We have a responsibility as brokers to know what's going on in our market. That's why you need to be careful if, like, for instance, maybe you're a Ballantyne person living in Ballantyne, like South Charlotte, and you have a client that calls you, or maybe you get a referral and they want to buy in Concord or Kannapolis or Mooresville. That's like 50 miles away. Do you really know those markets? Should you really be going there? Maybe. There's nothing wrong with it. You're legally allowed to. But if you don't know the nuances, you could get in trouble. You need to have some sort of way of learning what's going on in that market that you're choosing to go to. And people do it all the time. I see in the MLS sales when I'm doing my market research from South Park agents all the time. They come up here to Concord. That's fine. They get the lead. They got the lead through the internet probably, and that person ended up wanting, because we're kind of unique here in Charlotte. Charlotte is where the people work a lot of times, but they don't want to live in the city limits maybe. So maybe because of school assignment or maybe because of taxes being a little bit lower, they end up choosing some of these outlying cities and towns from time to time, like Mount Holly, Huntersville, just probably because of the proximity to the lake, but the traffic's kind of heavy out there. But still, and that's still in Mecklenburg County, but Mount Holly's in Gaston County. Concord and Harrisburg are in Cabarrus. Monroe is in Union County off to the southeast. So people don't mind driving 30, 40 minutes, but then coming into work. But they want to go away to get home sometimes. Well, if you're living in Monroe and you have a client that wants to buy in Mount Holly, you need to have some way of learning what's going on in Mount Holly that your client needs to know. Things that would matter to them. And it might be that you have a network of brokers and one of your friends works in Mount Holly. So you're like, look, I could either refer this client to you, but I really don't want to because I could use the paycheck. Nothing wrong with that. But what can you tell me? What can you tell me about Mount Holly that I need to know that you disclose to your buyers? That's why it's good to know other brokers in other markets. That's not that far away. You could certainly show 10 properties in Mount Holly in a given day and drive back home to Monroe. But if you come to Concord, do you know about the landfill? Do you know about Wallace, the poop farm, I affectionately call it? Do you know about Concord Regional Airport and the air traffic? Any town has those things. There's cancer clusters for thyroid cancer in Mooresville, I think, and in Huntersville, I think there's like an eye cancer cluster, and that's just a thing that has happened. There's no official blame given yet, but is it Duke Energy from coal ash beds? It's not been studied enough to be a definitive yes, but as a broker, I'll sell a house to somebody, especially somebody with babies, I'm going to disclose it. I'm going to say, hey, this is a thing you might want to look into for yourself. I can't say 100% either way, but this is a thing that I've seen in the news because it's been widespread enough that it made the news. It made some discussion groups. So you kind of need to know what you're doing, where you're doing it. And then finally, when listing a house, a listing agent is told by the seller that part of the roof leaks badly when it rains. That's my favorite phrase. But the moisture so far is being contained in the attic. The listing agent forgets to talk about it. They forget to put it in the MLS, and they forget to disclose the problem. The agent is found guilty of negligent omission. They left it out. They should have told people about it, but they left it out. They negligently omitted it. Because their failure to disclose it was unintentional, they're not guilty of willful omission, but their forgetfulness was enough for them to get in trouble. All righty. That's those 4 terms, guys. That's big. That's level 3. So get a good handle on that. And we'll circle back and talk about it again several times during this course. There are some other things that follow this topic in the comment section. Other things that we as brokers are not allowed to do. And you will not be surprised at these things. If you had to make a list of how should real estate agents behave, this is probably what would be on your list. We need to keep the promises we make. Don't make false promises. Don't say, yeah, just go ahead and buy it. I'll get you that those covenants and restrictions for the neighborhood. I'll get those to you later. You don't need those now. Just go ahead and sign the offer. Go ahead and sign the contract. You promised it, and if you don't deliver, you're in trouble. For one thing, that's something you would definitely have to give them. Paying somebody that doesn't have a license, improper commissions, meaning they referred you business. You can't pay them a referral fee if they don't have a license. That means, what if you know somebody who's a mortgage lender and maybe they talk to somebody? Usually it's people come to us first and we refer them out to a mortgage lender, but sometimes the mortgage person finds them first. And if that mortgage lender sends you business and expects you to pay them a fee in exchange for sending you a contact, a lead, that's not allowed unless that mortgage person has a real estate license, because you've just now paid someone without a license. I'm sure that happens a good bit. Or inspectors or brothers and sisters and family. They love you. They're sending you the business, but they kind of want something in return. And if you pay that unlicensed person for that lead that they sent you a referral fee, you can't pay them a referral fee if they don't have a license. This next one, unworthiness and incompetence, another word for that we'll get into when we talk about agency, because one of the requirements that we have as someone's agent is called reasonable skill and care. We must have reasonable skill and care. We must know what we're doing. We need to be competent with what forms to use, which forms, what kind of contract and addenda and amendments, and how do we make an offer. People need to be able to rely on us to know how to navigate the process and what's supposed to be done. And if we don't, and someone complains, we could get disciplined for that. And then, it's prohibited that we discriminate. Discriminatory practice we'll get into in another unit about fair housing. We basically need to make sure real estate is fair to everybody, accessible to everybody, regardless of those protected classes we talked about. Another one is that we can't practice law, meaning don't try to write a form. Don't make a form. You can fill in the forms they give us. We can fill in the blanks, but we can't write them and create them from scratch. Here's how that could actually play out. Your buyer wants you to make an offer, but they find out that there's multiple offers because you ask, right? They say, does this property have multiple offers right now? And so you reach out to the listing agent and you say, well, do you have more than one offer? Are we going to be competing? And that agent might say yes. Well, then your buyer says to you, well, look, I want you to create from scratch a form called an escalation clause, which says whatever the highest offer is on the table, I'm going to beat it by $1,000. That's a very real possibility that a buyer might ask that, because an escalation clause is something that's done in some markets. We don't have one of those forms here. There is no pre-made fill-in-the-blank escalation clause form, because it's tricky. Because one thing that's illegal when it comes to contracts is that if an agent calls you, if you're the listing agent and an agent calls you representing a buyer and they say, hey, I saw your listing, my buyer likes it, we want to make an offer, do you have multiple offers? You have to have the permission of the seller to tell them the answer. The seller has to give you permission whether you can say if there's multiple offers or not, because that seller may not want you to tell everybody that there's already offers on the table. That makes sense? Sometimes people assume that it's always good to tell everybody that there's multiple offers because they're going to just get desperate, get like super excited and eager to make another competing offer. But in a market that we've had these last few years, there's buyers that have failed 5 times in a row. They've made offers that have lost to other offers over and over and over, and they're worn out. They're burned out. And so if their agent asks you, are there multiples? And you say, yep, there's multiples, you better have your seller's permission to disclose it, because that might be the buyer who doesn't want to be competing. And they're like, nope, I'm out. I don't want to compete because I've lost 5 in a row and I'm over this. I'm just going to wait till I can find one that I'm not having to compete with other people on. So you must have your seller's permission. This is a testable item, by the way. You must have your seller's permission to disclose that there are multiple offers. Now, here's the next question that we get when we're a listing agent and somebody wants to make an offer. A buyer agent will call you and they'll say, hey, remember we were in that pre-licensing class together with that weird bald guy? He was our instructor, and we both passed, thank goodness. But, we're buddies. We go way back. I would love to have this deal with you, have a cross sale with you. I'd love to work with you. What would it take for my buyer to be the winner? What do we need to offer to beat out those other offers? Just between you and me, just tell me what the highest offer is so that I can beat it. Do you think that's allowed? Actually, and officially it is allowed, but here's a better question. Whose permission would you need as a listing agent to give them the answer to that question? And it's not the seller's. It's not the seller's permission that you need to disclose what the highest offer is on the table. Whose permission do you think you need? Some good, there's a right answer right there. Good job. And there's a good guess. There's another one. Good job. Here's a hint. You're never going to get this permission. I hope you'll never get it, because that person would be crazy. The permission you would need to disclose what the highest offer on the table is would be from the one making the highest offer on the table. And would they ever be so dumb as to tell their competition what they offered? Hope not, but maybe, but I doubt it. So that's whose permission you would need in order to disclose to everybody. But, I bet sometimes it happens. I'll bet friends talking to friends, buyer agent, listing agent, their buddies, between you and me, what will it take for me to work with you? And the listing agent probably would rather work with their friend, because the agent that's currently the highest is the big jerk that screwed him over last time. We keep score. When we have a cross sale with an agent that's particularly difficult, we don't forget. Now, we can't not pick, or we can't give advice or talk trash about them to other people, but we can at least be prepared in our minds and be like, oh boy, here's this person again. They were a nightmare to work with last time. I hope it goes better this time. So I'll bet sometimes a listing agent would be like, let's just pretend this person came in higher and let me help them along and tell them what they need to come in with. Not allowed, because you're not going to get the permission from the one who did make the highest offer. So that's what an escalation clause is kind of asking you to do. That's why they're kind of tricky. And a Real Estate Commission of North Carolina says, just don't do them. They'd rather you not, because how do you tell somebody what the highest offer is that they need to beat without disclosing what the highest offer is and not having permission to do so? It's impossible, right? So therefore, your buyer, back to the original point, your buyer asks you to write an escalation clause because it doesn't exist. There's no pre-printed one. They want you to write one from scratch. You can't do it for the simple reason that you're not an attorney. You can't draft language. And so that's the long way around to explaining that point. There's other things too. All we can do is fill in the blanks. Don't write all the way around and down in all the margin and get super complicated. You need to just keep it simple. Put the word or phrase in the blank that goes there, and don't try to practice law. Violation of any rule. There's actually a rule in the license law or commission rules that says it is a violation to break any of the rules. It's brilliant. It's like, thank you for that. Okay. And then lying about anything. That's another one, not allowed. This last one is a weird legal term that may not be easily understood. And the word is injunctive relief. Injunctive relief means that the commission can seek injunctive relief against somebody that they find out is doing real estate without a license. I had a listing one time and I got a phone call about it. And the guy was asking questions about the listing, and that's not weird because, as far as I knew at the moment, it might have been a buyer. But the more questions he asked, then I kind of started thinking, well, this doesn't sound like a buyer. Maybe it's an agent asking questions for their buyer. So I asked, I said, "Are you an agent?" And he said, no, I'm not an agent. And I said, "Oh, well, then you're thinking about buying it?" And he's like, well, no, I'm calling on behalf of an investor because I know of an investor that likes properties like these. And what I try to do is find opportunities for them and then tell them about them. And so, being an instructor, I kind of a little more sensitive to things than I used to be. So I finally just said, "Look, man, if you're not the one who's going to be buying it and you don't have a real estate license, then what you're probably doing is illegal. You're practicing real estate without a license by trying to bring him business. And if he's paying you to bring him these leads, he can't pay you if you don't have a license. You're acting like a broker." He basically excused himself, got off the phone, and never heard from him again. That's the kind of person that we're talking about here. Somebody trying to do real estate without a license. That's something the Real Estate Commission is going to pursue because they want to make sure we keep our status in this industry and its sanctity at a certain level. Make sure that the clients are protected, consumers are protected. And a consumer is not protected if they end up working with somebody that actually doesn't even know the laws and rules and doesn't even have the license. So the commission is going to go after that person and seek injunctive relief in a court of law, sue them, come after them in court because they're practicing without a license. What are the things that could happen if you get found guilty of these items? Well, one of them, I didn't think we saw it in the thing I shared with you this time, but last month I saw it, just a surrender of the license. If it's bad enough, the broker might be like, "I don't want to go through the hassle of the trial. I don't want to admit what I did. Let me just give you my license back. No harm, no foul. I will excuse myself from this business." License surrender. When you see those in the discipline section, it's kind of disappointing because they say, well, it was a license surrender, therefore no details will be provided. So you never find out what actually happened. But that's one of the possibilities. The other imposition of restrictions, that's what we've already seen. But, the reprimand, censure, suspension, and revoke. But there might be conditions to those things. And we saw that on the suspensions. They were suspended, but then the commission suspended the suspension probably as long as they did some coursework to get him better, to improve. So there might be conditions for relicensing. And then the word commingling, I think we've run into already. Commingling means just mixing up someone else's money with yours, meaning the firm's. So when your client writes a check for earnest money, that's the other check that your client needs to write when they make an offer. The first one is that due diligence money that we talked about a minute ago that was like crazy, non-refundable, and it's made out directly to the seller. So due diligence money made out to the seller. Earnest money is made out to whoever's going to hold the earnest money. Let me write it down. Due diligence money payable to seller and non-refundable. Earnest money is something that you may have heard of before because it's been around forever. We used to do it before we even did due diligence. Due diligence money was not a thing in this market until, I don't even remember, like 10 or 15 years ago. Earnest money, though, is pretty much a promise. It's another word called good faith money. You might also see it called good faith money because you're showing that you're showing good faith as a buyer, that you're serious about buying the property. It is refundable with a condition. If the buyer backs out in a certain time frame, they can't just back out all the way up to closing. If they back out within what's called the due diligence period, which we'll get into later, which is probably essentially about a 3-week period, 3 or 4 weeks from the moment it goes under contract, or maybe a week or two before closing. It'll be a due diligence deadline date that is set when the offer is made. And so if that buyer backs out during that due diligence period, then they are entitled to get their earnest money returned to them. So that's why it's refundable. So where does this earnest money need to go? Who keeps it? It sits in a trust account. And that trust account could be at either of the firms. Could be the listing agent's firm. It could be the buyer agent's firm. It could also be an attorney. Pick a closing attorney, and they have a trust account. So it could be either firm or an attorney that's holding that money in trust. And whoever the person is that has a trust account where the money is going to sit, the thing about a trust account is trust money is other people's money, and it must never be mixed with the operating expenses, the bank, the checking account of that firm or that attorney. Whoever's got the trust account, it needs to be nothing but other people's money, never their own money. So that's what we're talking about with commingling. If you end up commingling, that would be where you have your own money in this same account, or you put their money in with yours. Some more stuff coming up here is level 3. And we've talked about some of it because I gave you a pretty broad overview of things these last couple nights. Advertising. It's spelled out in the comment section. So be sure I'd say read at least the first 10 pages of the comment section before next week. And to do advertising, to advertise a property, you need to have permission of the owner. It's built into the listing agreement. It says, will you let me advertise? Check the box. But yeah, got to have a specific information or explicit permission of the owner. And then also the broker in charge. Your broker in charge must approve the ads you run, whether it's an Instagram post, Facebook, print ad, anything. And then part of that is the discrimination thing, making sure there's no discrimination in the ad verbiage, but also it's in the blind ad thing. And it talks about that in the comment section, how a broker must admit they're a broker in the ad. You can't leave all that out and just let people assume that you're the seller. Delivering documents. Anytime your client sells or signs something, you must give them a copy, and you must do it immediately, but not later than 3 days. We see this phrase several times in this course. So immediately is when you should give it to them. But if you can't, it's going to take a little bit. Absolutely drop dead no later than 3 days. So on the test, if it says some situation, and then it asks, when must this document be delivered? And if the answer choices are immediately, 3 days, 5 days, or 7 days, the best choice, the best answer is the immediately one. But if the answer choices are 3 days, 5 days, 7 days, or 10 days, then the best out of those 4 would be the 3 days. You with me? So in real life, they want you to deliver documents to your clients, to people that have signed things no later than 3 days, but if at all possible, right away. That's so much, this sounds silly because you're like, well, how hard is it? You just email it to them. Yes, because that's how we pretty much do it all the time now. Or DocuSign or something called .loop, other sorts of signing softwares. But a lot of these rules come from back in the day when email wasn't so prevalent and we had to actually deliver things by hand or fax them or worst case mail them, and there's like a 3-day trip on the postal truck. That's why it says 3 days, because it usually takes something a couple of 3 days to get to someone with snail mail, which all of this is kind of irrelevant now because you can just hit a button and send somebody something within the hour. Maybe that'll help you remember the 3-day thing. Back when you had to actually mail it, it would take 2 or 3 days. Then we already learned this. You must keep your records for 3 years. For every transaction, everything that went on, all the email trail, all of the text message trails, any sort of ads you ran on social media or in print, need to put all that in a file and keep it for 3 years from when it when it stopped being a transaction. I said it that way, stopped being a transaction, because not everything closes successfully. Hopefully it does, because that means you get paid. But maybe it goes all the way up to the week of closing and then somebody gets crazy, falls apart, the deal doesn't happen, the buyer walks or the seller breaches, and you end up not getting paid because the deal never closed. But you still have to keep the documents, still have to keep the file for 3 years. So all the failed to close things, and the ones that did close, most of them close. But you got to retain those records for 3 years. They can be electronic. You don't have to print it all out, stick it in a big file folder or manila envelope. You can keep it anywhere electronically. It'd probably be good to have redundancy and maybe keep it 2 different places, one on your computer or in a zip drive, and the other would be maybe on the cloud storage somewhere. Some more general provisions. You must have permission of the owner and the broker to charge them money. What are you going to charge? They need to approve it, obviously. So, brokerage fees. You're listing the property with the seller, and maybe you choose to list property for 6%, and you don't negotiate. Maybe that's your chosen way to do business, and that's okay. It is okay for you to tell the world, my commission that I charge is 6%. There's nothing wrong with it. One second. There we go. Because you can run your business however you want to. The only limitation is the laws and the rules, and there's no law or rule against what you're allowed to charge, except your BIC might have a requirement. So your BIC, your firm, might have a policy and procedures manual, and in that policy and procedures manual, it says, it could say many things. It could say, we give our agents the freedom to choose to charge whatever commission percentage they want to, but we're going to take a cut from whatever that is. Or they might say, look, we don't want to give you too much freedom because we don't want you to lowball all the time, and we'd rather you charge 5.5 at the very least. Charge 6 if you can, but if you have to negotiate, don't come any lower than 5.5. It is your BIC's right to set a policy telling you what you can charge. So between you and your firm, you can choose to charge whatever, but your limit, as long as your BIC allows you to. There are some brokers who choose to list property and charge, I guess, fee for service would be the best way to say it. I was going to say the word discount, but you can't say the word discount. You can't call that type of broker a discount broker, because the idea here is discount from what? What we also can't do is tell the whole world that the standard commission is. So you tell me in the chat, have you ever heard of somebody saying a standard commission, and what is it? What amount have you heard? Let me set it to just me real quick. Okay, now it's just me. What have you heard maybe out there in the world when somebody says, what's the standard commission rate? If you've ever heard that, what are some numbers? Yep, 5, 6, 7. Anytime you hear the word standard commission rate, it from here forward, from now on, it should perk your ears up and make you cringe because it is illegal. It is called the Sherman Antitrust Act, and it says to claim an industry has a standard rate is illegal. It is harmful to the public because then they feel like they're forced to pay a certain thing. When we should actually say there is no standard commission, everything is negotiable. However, I charge this. So again, you can say what you charge, you can say what your firm charges, you can choose to charge a certain amount, but you can't claim that the whole industry has a standard. So now when you see that on Facebook or when you hear that out there in the world spoken, just know, no, I don't engage in that. I can't support it. I can't go on record and say, yeah, the standard is such and such. There's no standard. Every commission is negotiable. You can choose not to charge. You can choose not to do the work for less than a certain amount, but you can't tell the world or claim that there's a standard commission rate. So if there's no standard commission rate, we can't call a broker who will, for instance, just put the listing on the MLS for $500. We can't call them a discount broker, although that's something else you'll see. What they are called properly is a limited service broker because they're limiting their service, and the commission allows that. The commission, real estate commission, says, okay, broker, if you want to make that available as an option, that's no problem. You can offer limited services to people. So you can charge somebody $1,000, and in exchange, you're going to put their listing on the MLS, and that's all you're doing. You're not going to make flyers. You're not going to run any ads. You're not going to post anything on Facebook. You're not even going to take pictures. They're going to provide the pictures themselves. This is bare bones, bottom of the barrel, lowest level. This is all I'm giving you. It's what you're paying me, and all I'm going to do is this one thing. Oh, you want pictures? Professional? Okay, I have a hookup, though. You want to give me another $500? Then I will connect you and get some professional photos made, right? It could be a la carte, fee for service. And that's a valid method of doing business. But whatever the brokerage fees are, you would have to get permission from the owner, an agreement from the owner that that's what they're getting. You're going to do it this stuff for this amount of money. And then over all of that, make sure that your firm is cool with it. Because not every firms allow limited service brokerage. They might say, look, we are a full service and that's it. We don't do the limited service model. The problem with a limited service model, if there were a problem there, would be how much do you charge and for what? And what if that one thing you agreed to do for them doesn't get it sold? And now they're mad at you, but you just did what they wanted. You put it in the MLS for an even $500-600, $1,000, and that was the deal. And they signed it and said, this is what I expect from you. You're going to put it in the MLS and that's it. The rest is on me. But they forget about that part of the deal. They're mad, maybe. And so they take it out on you and start bad mouthing you. That could be a thing that happens. And maybe that's a reason why a firm wouldn't want you to offer it, because they don't want any sort of misunderstandings coming around through the limited services being offered. But if they have confidence that they can handle it properly so that, and even if somebody does complain, they don't care because they did the best they could, so be it, right? But your firm has to agree. You're big. Drafting legal documents kind of goes in hand with that whole don't be an attorney. We can basically fill in the blanks. We can't get creative and write a bunch of language. Just need to put what goes in those blanks, the possible entries. Disclosure of offers. This is a big one. All offers must be presented. So if you're a listing agent, you can't not present an offer. And you might be sitting there thinking, well, why wouldn't you present all offers? Well, it might happen like this. Maybe you're getting multiple offers. Maybe you have 10 already. Maybe your seller is tired of all the offers that have come in, and your seller says, look, I don't want to have to choose between 85 offers. So let's just put a deadline and say that all offers are due by noon tomorrow. And that is not uncommon, pretty typical for somebody to put it out there in the world and say, look, this house, we're getting multiple offers and just need to bring your offers by noon on this date. What happens if an offer trickles in after that deadline? You, the listing agent, still need to present it to your seller. That's where it gets messed up. I think people are like, well, we literally have 40 offers in hand. We told them noon, but I got 10 more after noon, and my seller's already frustrated having to decide between the 40. So let me just forget that I even got these. That would be wrong, right? You have to present all offers, even the ones that come after a deadline that has been set. Even if they come in after the property has gone under contract. Because let's say 10 offers come in and your seller picks one, counters it, they go back and forth, they sign, and it's agreed upon and communicated. Now we are officially under contract. And then tomorrow, another offer comes in. Even though they knew it was under contract, they make an offer because they might be wanting to make the offer as a backup offer in an automatic backup position. You would still need to disclose that that offer came in. It might be that the offer was accepted and you just haven't put it in the MLS yet, so the whole world doesn't know that you're under contract yet because it's been like only an hour or so. And then in the meantime, you've got signed papers. It's officially under contract. It's signed and communicated, but you haven't been able to update it in the MLS. So you do get another offer. You still have to submit that offer. You still have to present it. You could certainly tell that agent, look, I don't think this is going to go anywhere because my client's literally just signed and it's all done. It just haven't updated the MLS yet. I was just about to do that. But as far as your seller is concerned, you must present it. And some agents might be like, well, gosh, they had such a hard time dealing with all those multiples. I don't want to confuse it anymore. Let me just forget that it's there. That would be wrong. Because they might want to take that offer that came in late as a backup offer. They might say, well, gosh, I kind of like this one better than the one I agreed to. Can I just swap it? Can I say no? Well, no, because you're obligated to them now. But we can keep them, if they're willing, keep this late coming offer in a backup position, which means we would include what's called a backup contract addendum, which means that if the first offer that is actually the one on the first position, if they fall away because maybe the buyer decides not to buy it because of an inspection issue, or doesn't appraise, or they just change their mind, they're allowed to do any of that as long as they're willing to walk away from that due diligence money. If that happens, then that person in the backup position automatically goes to the primary position. And your seller might like the confidence of knowing they've got an automatic plan B, right? Let's have an automatic break. I'll see you in 10. Welcome back. Last 45. Hang in there, guys. It's a little bit late. Probably had a long day. But let's try to make it. Oh, look. There's the last 2 points. We already talked about them. The permission of the seller is required to disclose that there are multiple offers. You as a listing agent probably need to handle this conversation when you list the property in the very beginning before offers start coming in so that you know what your seller wants you to do. Because again, it might not be the case that your seller wants you to tell everybody that there's a lot of offers because they might be worried it could scare away someone who would otherwise make the best offer. You don't know if that person you scared away would have ended up being the best one. So what I'll usually say to a seller is, here's how this works. We could get multiple offers, and if some agent calls me and asks me if there's multiple offers on the table, I would rather be able to say, I'm sorry, my seller has not given me permission to disclose that, because I don't want to risk my seller losing out on someone who is burned out and would choose not to go ahead and make an offer because just hearing that there's multiples. You with me? So I kind of counsel them on that, but it's up to them. I'll do whatever they want. And then the other one here is the last one, permission of the buyer to disclose the terms of the offer, usually the highest price. So you can't disclose that. As a listing agent, you can't tell what the highest offer is without the permission of the one who made the highest offer. All right. Let's talk about some broker in charge things. Every firm must have one. There must be a broker in charge for every firm. And then we saw this last night there toward the end. Even if you're not a firm, but you're a sole proprietor, and that's how you're going to be. That's what you're going to be to begin with. When you get that provisional inactive license and then you affiliate with a broker, first you're going to be a sole proprietor because you haven't started a firm of your own yet. So you yourself are a sole proprietor. And so sole proprietors need BICs just about every time, just about all the time. The only time you would not need a BIC is if any of these 3 things are not happening. So you need a BIC if you're going to hold trust money and have a trust account. You need a BIC if you're going to have agents under you, licensees reporting to you. And you also need a BIC, and this is the biggest one that keeps this that makes most people need BICs. Advertise or promote your business. Anything. Make a business card and hand it out. Now you need a BIC because you just promoted or advertised. Make a Facebook post. Even tell people proactively that you can be their resource to refer out. You don't even want to show houses or list houses. You just want to make referral fees. But if you tell people, call me for all your referrals, you just promoted yourself and now you need a BIC. You can't just sit by yourself at home anymore. You're going to have a BIC to do any of these 3 things. Speaking of the broker in charge, here's what's required. Must be an active license. You can't be a provisional broker, and you have to have experience, 2 years full-time or 4 years part-time. And you must complete that course given by the Real Estate Commission. It's called the 12-hour broker in charge course. And then the dates, the time frames are these. We talked about it already. If you go ahead and declare yourself broker in charge, then you must complete the course within 120 days. You need to hurry up and learn how to be a BIC so that you can do it properly. But you can be a BIC in the meantime, up to almost 120 days. I guess if you're taking that 12-hour course on the very last day, you could pretty much be a BIC for 4 months almost, and then take the course at the very last minute, but no later than 120 days. If, on the other hand, your plan is to just become maybe BIC eligible, or you're in no particular hurry to become BIC, maybe you're planning to start your own firm and declare yourself as BIC, but it's like you don't have to do it immediately, then you could go ahead and take the course now. And as long as your plans are going to happen within the year, you have a whole year to declare yourself BIC or BIC eligible once you have taken the course. So just know those time frames around the course. After you get it and become BIC or BIC eligible, then the only thing you need to do to maintain it is to stay active and to also take the BIC up version of the CE. Good question. Somebody asks, do BICs have to take electives? Yes. As a BIC, you still have to take 8 total hours of CE, 4 and 4. The 4-hour BIC up and the 4-hour elective of your choice. I said something just now. Let me think if I can remember it. It brought up something I wanted to point out. Take the required BIC up, continuing at each year. I'm sure I'll think of it later. And that's it. That's all we're going to cover out of the comments section so far. It's a good bit of it. It's probably almost half of the whole thing. But we're going to fold back in. What we still have yet to talk about with license law and commission rule are trust accounts and timeshares. Those are pretty short topics, but we will revisit this several times throughout our course so that by the time we hit it in the natural order of things, it will not be a mystery. You'll be really solid. Let me pull up the chapter 1 information. We'll just keep on going. Now we're in the textbook. We're going to cover chapter 1 and work our way on through in order, with occasional pauses to revisit license law and commission rule. So just as a reminder, read those units before class, reread them after class. Maybe you read them before class and then after class you go back through and that's when you mark what you see in the syllabus and mark those things in the textbook. That might be a good option. Answer questions at the ends of the units and do the review there at the end of each unit. Any sort of homework assignments that I give you, like the one this week, again, which is make up your own one each example of the 4 kinds of misrepresentation and omission. I'll put it in Notion as a reminder. And then study every day. Find that place, that time. If you need to get up a little earlier, stay up a little later, do it at lunch, go to Walmart, but sit in the parking lot. Whatever you need to do, you've got to make time for this stuff. This is just about a 45 minute topic here because it's literally definitions. It's just super basic concepts. We're going to see what the characteristics of real estate are, what the classes of property are, physical and economic characteristics of land, and then the concepts of land use and investment. What people in the real world, in real life, do is talk about these 3 things interchangeably: land, real estate, and real property. They just use one word and mean the other all the time. And it doesn't matter. But now it does for you because as a broker, you need to know the difference. So all of these 3 things are related to real property, real estate, things that are affixed to the earth. You can't pick up your house and move it without detaching it from the ground, right? It's a fixture. But there are things in your house that are not fixtures, that are not part of the real estate or real property. Those things are probably what you all have in common right now. All of us, I'll bet, looks like from what I can see, we're all sitting in chairs. And unless those chairs are bolted to the floor, we could pick them up and walk out the door with them, and therefore those chairs are personal property. Another word for personal property is this word called personalty. Let me put it in the chat. Personalty. And it's sort of like the word realty, right? They just tacked on the LTY at the end. So realty is real estate, and personalty is personal property. In the chat. So personal property just basically means portable. You could pick it up and move it. You can make personal property into real property, and that's called annexation. We'll get to that word on the slides in a little while. But annexation means you're annexing this personal property and turning it into real property. An example of that would be you want to install blinds on your windows. So you go to Lowe's, you buy the blinds, you drive them home, and when you bring them into the house and lay them on the floor, they're still personal property. But when you open them up, take them apart, and then screw them into the window frame, now they've become real property, right? It's not rocket science. But that's the difference. That's what we're talking about. It becomes a big deal, though, when the two parties to the transaction, the principals, the buyer and the seller, one of them thought something was supposed to stay with the house, but the other one took it off, detached it, and took it away with them. Now we have a big deal. Now it's a level 3, right? And so those are called fixtures versus personal property, and it's something that happens all the time. I'll give you the spoiler. I'll just go ahead and give you the punchline to this. The best way to avoid problems with fixtures and what people expect to stay versus go is to make sure it gets written into the contract. Make sure it makes it into the contract, no matter what was said verbally, no matter even what was promised on the MLS. It could say in the MLS, the seller could say, or the listing agent could write, the refrigerator, the washer, and the dryer all stay with the house. They remain with the house. But if the refrigerator and the washer and the dryer, which are personal property, by the way, if they don't get written into the contract that they stay with the house, and then the seller ends up taking them away because maybe the seller's mad at the buyer by that point because they're mad the price came in lower. They're mad that the buyer had the nerve to ask for them to fix some things. And so they're like, screw this. I'm going to take this with me. This will make up for me having to take less for my house. Well, then there's nothing the buyer can do about it. The buyer doesn't have it in the contract to be enforceable. What might even happen is the agents end up buying it. The buyer agent, if it's the buyer agent's fault, if the buyer told them to write it in the contract but they forgot, they might be the one, in order to keep that client happy and calling them again later, or maybe to keep them from reporting them and complaining to the commission, they might end up buying some stuff. I call it happiness money. Let's keep a client happy. Whether they have a reason to be mad or not, I'd rather end with smiles. So I'll buy something. If I'm making a $15,000 commission, I'll spend $1,000 to make somebody happy, right? How about compared to zero because they walked away and were mad at me and let the deal fall apart? Or even if they didn't walk away and the deal still happened and I still made the money, but now they're going to tell the whole world that they're mad at me, even if they had no good reason to be. So these words, land, real estate, real property. Let's look at land first. What is it? It's the dirt. And when you buy the dirt, what you own is underneath, on the surface, and in the air. There's not dirt in the air. We're just talking about the airspace. So theoretically, when you buy a piece of land, you own down to the center of the earth, the surface and everything attached by nature, like the trees and the bushes and the grass and the pond, if there's one. And then you also own up into the air. That doesn't mean you can keep an airplane from flying over your property, but theoretically, legally, that's what you have. You have subsurface, surface, and air rights. And you could sell or lease any of those three rights if you're the owner. You could give an oil company permission to drill into your ground, into your land, and pull out the oil. You could do that by lease, or you could sell it. You could sell the subsurface rights to them while you maintain the surface rights. You still live on the surface with your house, but then you let them drill on the other side of the property, and you sold them the subsurface rights. Or if you're like in the city, like in New York, I think over Grand Central Station, there's a building over top of it. So Grand Central Station sold the air rights to this company that I think it was, if it's not still, it was originally the MetLife building, I believe. That skyscraper is over Grand Central Station, and they are there because they have either they lease them or they bought them the air rights over that property. So that's land. Land is the most basic. When we add something to the land and build something permanent, human-made improvements, now we don't call it land anymore. We call it real estate. So real estate is land plus the barn, plus the house, plus the pool or the driveway or the fence. We're talking about real estate. The term real estate is land plus improvements. Those improvements, by the way, one of our first big words, tenement. The word tenement is another fancy word for the improvements that are made to land, like a building. In, I don't know, in my history, in my past, watching TV, watching movies, when I've heard the word tenement, it has been used in the case of like a broken down, kind of torn down old shack, like a not in good repair kind of structure. But we're not talking about that. We're just talking about improvements, structures. Those are called tenements legally. If we take that real estate, which is the land plus the improvements, and then we add into the mix legal rights that you have when you own it, that brings us to the term real property. So real property is the land, the improvements, plus this bundle of legal rights we're going to be talking a lot about. In other words, what can you do with it if you own it? What are you allowed to do with your property if you own it? You tell me in the chat. What sorts of things can you do with something that you own, real estate? That's a good one. You can sell it. You can add on to your structures in there. Yep, good one. You can tear it down. Yep, with conditions. If you have a loan on it, you can't tear it down without that lender's permission. But for the most part, sure, if you own it free and clear, yeah, you can drill into the ground. What's another one you could do besides sell it? You could give somebody the right to use it without selling it to them. There it is. Lease it. You could lease it out. Yeah, good one. All of those are your rights. You could also put a fence around it, not let anybody come onto it, right? You have these rights. Then there's some other rights that come into the mix too. What if your lot, your house, does not have direct access to the street? In order to get from your lot, your property, over to the street, you have to go across your neighbor's property. That right to go across your neighbor's property is called an easement. We're going to talk about it more, but it's called an easement. And when you sell your property that includes the easement across your neighbor's property, the right for the person that bought it from you, it continues. It continues and it runs with the property. It runs with the land. It's actually called an appurtenant easement. Appurtenant. Something that runs with the land is appurtenant to it. It's included. Because in North Carolina, at least, you're not allowed to sell property that is landlocked. Write that one down. Not allowed to sell landlocked property. All property must have access to the street or the road. And so this easement appurtenant, in other words, driveway easement, you have permission from your neighbor to have a driveway across a portion of their land to get to the street. They bought their land with that understanding that the driveway easement would be there too. And that runs with theirs too. The person who buys their property has to leave the driveway alone and allow that easement. So that's all the sorts of bundle of legal rights we could be talking about. And that bundle of legal rights has a big fat word attached to it, and it's called hereditaments. Hereditament. I have to count every time. 5 syllables. Hereditaments. So we had 2 big words. We had tenement, which is improvements that you build on the property. Hereditaments, which are those legal rights. So you could also say that the difference between real property and real estate is that real property includes hereditaments. Some of this stuff you're just going to have to wedge into your brain and memorize it. All right. Real property is the land itself, things attached to the land, and things that run with the land, i.e., legal rights. Personal property is all the other stuff, like the cars and guitars, and motorcycles and chairs and furniture, and light bulbs as long as they're not screwed in yet. Getting the point? So you tell me in the chat examples of permanent improvements. Got a question in the chat. Someone said, are you talking about like having the right to hunt on land? Is that what you mean? Let me change. Okay, this is everyone. If you want to make your comments seeable to everyone, you're going to have to set it, because I've given you permission to do so, but you guys still have it set to direct message. It doesn't matter to me either way. Hunting land, if that's what you mean, would probably be given to somebody with what's called a hunting license. To license your property to someone is not the same thing as to lease it to them. It's really, it's revocable. You could revoke it at any time. You owe them nothing. They could even pay you for it, but you're giving them a short term. It's no possession of any sort. They can just come and hunt. They could come and fish, fishing license, hunting license. It's pretty much the lowest level of the permission to use a property. And you could back out of it at any time. They have really no say-so other than a right to use it for that one purpose that could go away at any moment. So it's pretty limited. Oh. Do you have to have road access on hunting land? No matter what the property is, the owner always has to have access to the road. Sometimes you'll see some pretty weird shapes, and it'll have this long, kind of little skinny shape all the way to the big acreage, and that's because they have to have that right of way, that road, to connect it to the main thoroughfare. Some characteristics of real property. These are the things that make real estate unique and special. Physical characteristics of real property include the fact that you can't pick it up and move it. It's not portable. It's immobile. These aren't amazing facts, I know, but physical characteristics, you can't move it. That's what makes banks and lenders so much more willing and okay with loaning you a lot of money to buy it, because they know you can't steal it. You can't just drive it to South America in the middle of the night and disappear like you could a car or a motorcycle or something. Personal property is much more stealable than land is, right? So immobility. It's also indestructible. Yes, you could probably make it unusable for certain purposes. You could like blow a big hole in it, like a big crater. You could put something in the ground to make it hard to grow things in, but for the most part, legally, it's indestructible. It's that land's going to be there. And then the biggest one that everybody's most familiar with is uniqueness. Every piece of real estate is unique, like snowflakes. Although what you're probably thinking right now are those neighborhoods that look exactly alike. Those little cookie cutter neighborhoods where every house kind of looks real similar, and it's like blindfold you and spin you around twice, and you wouldn't know if you're looking at the same one or not. But still, legally, for the most part, every one is unique. It's that property with that address at that location on that dirt. These 3 physical characteristics are what really make real estate such a good investment and so much easier to get a loan at a lower interest rate. You ever notice that mortgage loans are about the lowest interest rate you could get compared to credit cards or motorcycles or cars? It's because they're safe, they're immobile, they're indestructible, they're unique. And yeah, the structure on it could get torn down, but there's your insurance to cover you for that. Now let's talk about economic characteristics. Scarcity. From an economic perspective, what makes property worth more or less? How scarce it is. And we've been seeing that in this seller's market we've been in for the last several years. And we're still in a seller's market. It still favors sellers because right now there are still more buyers than there are properties to be bought. So when that's the case, sellers can demand higher prices. They can get multiple offers because people fight over them because there's more people who want them. We have a supply problem. Well, maybe not problem. It's not a problem for the seller. They're pretty happy about it. It's a supply imbalance. Scarcity is an economic characteristic. When things are not available, the ones that are available are worth more. Location, right? Lake Norman, waterfront property, Myers Park. In that specific neighborhood, you don't go outside of Myers Park and you're not still in Myers Park. You're either there or you're not. It's closed in with the city. You can't just add to it like you can when you're out in the suburbs. So Myers Park, Dilworth, Madison Park, Noda, Lakefront, all of these things are about location. The three most important words in real estate: location, location, location. That's right. That's how important location is, right? It affects value. Certain neighborhoods that have really nice homeowners associations and amenities like clubhouses. There's one in Kannapolis that just about died out, but then came back strong. But when it came around the first time, called Kelswater. That's it, Kelswater Bridge. It came around, and the builders just went crazy, and they built $500,000 and $1 million houses, and then the market kind of started getting soft, and it didn't take off so great. But part of their deal was to have a really nice swim and tennis facility, and the HOA dues included fiber internet. That was huge 10 years ago or more, right? Now it's back going pretty strong. I don't know if they still do the fiber thing or not, but being the location, because you're buying in there and you have that, you could get more money for your property because it has this unique set of advantages. Improvements, of course, the more things you put in it, you fix up the kitchen and bathrooms, you put a pool in, maybe that might help or not. May or may not increase value, but it affects value, whether it increases it or decreases it. For instance, with the pool, is it gonna, if you put $30,000 into an in-ground pool, do you get to add $30,000 to how much you can get for your house? No, probably not. You're still subject to whatever things like it have sold for and are worth. Now, will it be worth more with the pool? Maybe, probably a little bit. Not what you put into it though. Probably, maybe 5 or 10,000 more, but certainly not what you paid. Because some of that is just for your own personal enjoyment. You made those choices. And another person might not have chosen to make a kidney-shaped pool. They might have rather it be a rectangle. And your buyers, they're okay that it's a pool, but they would rather it be different. So the improvements may or may not help. And then if you choose to put an above-ground pool instead of an in-ground pool, then the whole value thing is even all the more different. It might even take away. I once sold a house to a family friend, and he's a old-timer kind of guy, and he didn't want to buy the one house that really fit their needs, that fit both he and his wife, both of their needs. The only thing he could complain about it was that it had an above-ground pool. He didn't even know how pools worked. He thought it was tied into the water supply, and he was going to have a higher water bill because of the pool. And I knew better because I had one growing up. And finally it got to the point where I'm like, we've looked at a million houses. This is a nice little brick 1,600-foot house in the country, backs up to woods, perfect for this guy. Basically was what I call a professional Boy Scout. He literally worked for the Boy Scouts of America. He dressed like one all the time. He was a woods guy. He was in the woods. And his poor little wife loved this house, but he didn't like it only because of the pool. To the point where I said, look, let's just be done with this. If you buy this house, I will remove the pool. And I rented a truck from Lowe's after closing, and I went over there and I dumped the water out of that pool, and I got everything all scooped up, took it all apart, and the pieces were, because I'm on this 5-acre piece of land, I had the pieces of that pool off in a far corner for a couple of years after that. I didn't even bother to find a place to throw them away right away. But that's all it took, because guess what? The job description in this business is get to closing. That was his only obstacle. I'm going to find a way to get rid of his obstacle. There's nothing wrong with doing that, right? It was at my expense, but I made a commission and kept them happy. He ended up putting a building from Lowe's or Home Depot. He brought one in to put it where the pool had been and basically turned it into a man cave. He had his little Boy Scout cot in there, had his little desk from 1957, and he set up a video camera so he could see who came in the driveway while he was sitting there in his little cot in his building. Whittling something, probably. So the improvements can add or subtract. Any of these can subtract as well. And then permanence. Economic characteristics of real property have to do with how permanent these things are. When it comes to determining something's value, in particular when an appraiser does an appraisal, that appraiser is trying to solve the question, answer the question, is this property being put to its highest and best use? So when it comes to how you're using the land and investing in it, it could be that it's like my case again. Am I using this to its highest and best use financially? No, not at all. Because I'm sitting in here in this old house on these 5 acres and I'm paying taxes on that 5 acres. It's embarrassing how much. It's $11,000 of property tax because I'm in the city limits. It's basically a house payment every month all at once to pay off those taxes. And I'm not getting anything out of it right now. I'm just kind of sitting waiting for a buyer to come along and buy it for industrial purposes. So no, I'm not using it to its highest and best use. If I had resources, if I maybe did a GoFundMe or came up with some investors, made a couple of $1,000,000, maybe I could put some mini storage buildings on here. And then I would maybe be using it to its highest and best use for mini storage because there's apartments and stuff around here that might use it. So how will I make the most money? That's what this question is. And we'll get more into it when we get to the Unit 13 is about appraisals and doing market analysis and figuring out what something is worth. By the way, this is testable. There is only one highest and best use at any given time. So how many highest and best uses are there? One at a time. They might change over time. Once upon a time, this property I'm in was at its highest and best use for residents. But then the zoning changed. Now the highest and best use would be something industrial. Let's see. Is the kitchen one of the biggest selling points in a home? It's big because that's where everybody group meets, right? That's where it's the hub. So that's a good place to put money. If you're going to spend money fixing something up before you do the guest bath, before you do a bedroom, if the kitchen really needs some help, work on the kitchen. There are restrictions. Even though you own a property, even if you don't even have a loan and you just own it free and clear with no mortgage, you still have limitations as to what you're allowed to do with it. And that is through two things. There's both public and private land use restrictions. We're going to get more into these when we hit their own chapters, but public land use restrictions mean zoning laws. What is that property zoned for? The purpose is to make sure that the county or the city is growing in a healthy way, because you don't want to end up with a town that's just got terrible placement of things. So the planners would I'm just going to use this line that was already here. They'd say, okay, in this part of town, say this is the county, over in this part of town is where we're going to put our houses. So that's the residential zoning. And of course, in the downtown section, that's more residential. But over here, off in the far reaches of town, let's make it industrial, because we don't want to look at the asphalt plant, and we don't want to look at the warehouse and the treatment plant and the big power substation and all that stuff. But then over here, we have this big city over here toward this direction and outside of the county. So let's make this section commercial. This has got commercial zoning. And so that way we've got nice, safe property appreciation going on down here, where the residential stuff is. There's nothing better for valuation, for values going up, than similarity. So you want to have similar things in order to increase the chances of values being stable. So public land use controls have to do with zoning, but then there's also private land use controls. And by that, I mean something called restrictive covenants. You see the term restrictive covenants, that means the seller of the property put some rules in place for any buyers to follow. So if you buy a property that has restrictive covenants on it, you have to agree to those in order to buy it. And us as brokers, we are required to give those, as those are material facts, to disclose what the restrictive covenants are. What sorts of things do I mean? Maybe it's a seller who owned 100 acres and they decided to sell it to a developer. And they say to that developer, I'll sell you my 100 acres for you to develop into houses, but here are my conditions. I don't want any of those houses to be less than 2,000 square feet. I want this to be a nice neighborhood, like a really substantial, solid neighborhood. So no less than 2,000 square feet, and they have to be all brick. I require that they only be all brick, no vinyl, no wood, nothing like that. And I require that they be single level only, no two-story homes. All of those things are restrictive covenants that a seller could put into place and require the buyer agree to before they buy it. Now let's talk about how you enforce these things. If you break a zoning law, the city's coming after you. They're gonna fine you. They could put a lien on your property and say, you broke the zoning law. We gave you a chance. Now you have to pay this money. Oh, you didn't pay this money? We're putting a lien on your property. The private land use control, these restrictive covenants like the brick, the 2,000 feet minimum, the fencing, it could be a fencing requirement. You can't do chain link. It has to be no higher than a 6-foot privacy fence made of vinyl. If you violate a private land use control, the city or county government's not coming after you because it's not a public one. The people who made it, if they find out about it, or your neighbors who also agreed to those same rules, they would be mad at you for breaking the rules that they're agreeing to. Any of them could sue you, bring you into court, sue you civilly to enforce those private land use controls. So, yeah, your land is your own, but maybe not 100% only for you to say what you can do with it. It could have some conditions. When you buy real estate as an investment, as I'm sure some of you, if not all of you, are interested in doing, we'll get into what makes those advantages and disadvantages, but the leverage is probably the biggest one. Leveraging your money. Would it be better if you had $1 million? Would it be better to buy one property for $1 million and own it free and clear? Maybe. If you're a Dave Ramsey fan, that's probably what you would do. That's a choice. It's a choice. Or would you leverage your money, and instead of buying one property for $1 million free and clear, would you buy two properties for $500,000 each and then finance the other half of each of them? Right? You're using your $1 million to buy $2 million worth of property because you're borrowing from someone else at pretty good interest rates, so that now it's income producing. Maybe it's commercial real estate. Tenants are paying you to run their hair salons and their CPA businesses, and you've got a nice little strip mall full of people, businesses paying you money in rent. And instead of tying up all your money, you've got leverage. other people's money is paying for your mortgage. And so of enough years of doing that, you end up with those mortgages paid off a lot faster than you, and with less risk, right? Because you had money coming in. It wasn't just your money. And we'll talk more about advantages and disadvantages. The disadvantage, the main one about real estate as an investment, is that you can't cash out fast. It's called liquidity. How liquid is your investment? Well, anybody have a savings account? Who's got money in a savings account? What is your rate of return in that savings account? Are you proud of it? It's low. It's super safe, but it's really low. And therefore, I mean, it is what it is. You just keep it there so that you won't spend it too easy. You keep it there maybe so you got some money available for the whatever, and you don't want it in your checking account because it's too easy to swipe that card. You at least have to go in and transfer and make yourself consciously put this thing over there. But you can get it out pretty quick. And your checking account is even easier than that. Literally swipe it. Every time you shop, it asks you if you want to pull money out of your own account, right? So that's really liquid, but real estate, it's going to take a minute. You're going to have to put it on the market. You're going to have to find the buyer. It's going to have to go through the closing process and close, and then finally you get your money. So that's the biggest difference of real estate as an investment. There are ways to make it more liquid, like you could have an outstanding line of credit called a home equity line of credit that pulls equity out of your property when you need to spend it. But we'll get into that later. And then finally, what can you do in real estate? What does it include? Well, certainly it includes what you're thinking about right now, general brokerage or some sort of selling houses, or maybe your own property that you want to buy and sell, but also appraisal. Appraisal's a big part of the real estate business, and they're in demand. If you can become an appraiser, not a bad side business, not a bad main business. It's just that it's a little more involved in that you've got to take, I think, like 5 classes at like a community college is fine. That's not so bad. But then once you finish those classes, you've got to find another appraiser who's willing to let you be their apprentice for a year. And you better know that they're going to take all the money. If an appraisal costs $500, you're not making 500 while you're in the apprentice phase. You might make 50, but you're learning. They're letting you do the work and learn how to do it, because it's tough work. Learning how to figure out what something is worth. After that year, you get a pretty big raise because you'll probably go out on your own, and now you get the 500 or 600, all of it to yourself, and now you're making 6 figures. But that year is tough to do because every appraiser I ever meet, and I try to meet all of them that ever want to come list my properties, that ever have to come appraise my listings, that's what I meant to say. I chat them up, and I haven't found one yet that several have done the apprentice thing, and they've had apprentices under them, but most of them are like, I don't do that anymore. I'm basically creating my own competition. I'm too tired. I don't want to be in charge of them. They're sort of like a broker in charge over this person for a whole year. So that's what appraisals are like. Property management, helping somebody who has investment property, and your job is to manage it and get the most out of it. Make sure that it's producing. Make sure that you keep it rented, keep tenants in place. And if a tenant needs to go away because they're end of their lease and they're still living there, they need to be evicted. That's your job too. And then you make a commission based on the monthly rent, like maybe 8 or 10% of the monthly rent, perhaps. Financing, you can get into the mortgage business. Property development, you could have your own enough funds and ability to borrow to make entire subdivisions. Counseling, telling people what their options are. Education, welcome, here we are. And then professional organizations, there's lots of those. The one that you're going to probably join first once you get your license is the Realtor Association. And by the way, there's only one A. There's only one A in Realtor. There's not Realtor. It's Realtor, not Realtor. From here forward, you have to pronounce it right, okay? I know it's all wrong on the movies and TV. Well, that's the first one. That's a trade association that you join so that you can elevate yourself, show that you're willing to adhere to a higher code of ethics. Yes, you're learning the laws and rules now because the commission says here's what you need to learn to get the license. The Realtor Association includes a code of ethics, which is more than just about the consumer. It's also about how we behave with each other. Let's not be jerks to each other. One of the items on the code of ethics is don't solicit business from your competition. In other words, if they have a client signed up, don't steal that client. It's called tortious interference with contractual relations, and it's illegal. So then there's also that alphabet. Remember the first hour I was talking to you when I was doing a little introduction, and I talked about SRES and all these letters. So you can take those courses, get the designations, and affiliate with those organizations to learn and specialize in certain components, certain aspects of the business. And then finally, here's that realtor thing again. All realtors are licensees. You have to have a license to join the realtor board or the realtor association, but not all licensees choose to do so. So realtors are not, they're all licensees, but not necessarily all licensees become realtors. With that said, I'm going to turn you loose. Put your name in the chat for me. Bring me some homework for next Tuesday because you're off on Monday. And let me know if you're having trouble with joining up Notion. Those two people that mentioned it, I'll just re-invite you, see if it'll work that way. Have a great weekend.